Your Honor, I would like to mention item number 23.
Item
23.
23.
Your Honor, matter may fix 29 this month.
When?
Pardon?
What is your submission?
Matter may be adjourned today and taken up in 29
Your
of
for?
this month. For Tigame.
For state government.
Tigame, Tajam Game.
The government. For the petitioner.
Yes, Your Honor.
Okay. 23.
29.
29. This is with IA. Mr. You are Mr.
C. Peter.
Appearing on behalf of. You are appearing on behalf of
Tigame.
the government. Direct counsel for the petitioner.
Yes, Your Honor.
Pray for listing this matter.
29 of this month.
29 of this month. Item 29.
Item number 23, Your Honor.
20.
23. Item number 23. And matter may be fixed on 29 of this.
Okay. 29 on 29. The prayer is allowed. List this matter on 29. Okay.
Masuk.
May I, my lord?
Yes.
My lord, I would like to mention item number 11, Your Honor.
Item 11.
11. Matter may be fixed after 3 weeks due to main counsel B. Arun has out of station, so it's joint petition.
Yes, yes. LCR also received here. You are Miss?
T set.
Okay. Your name is there?
Yes, sir.
Line of counsel for the petitioner. You want adjournment?
Yes, sir.
When do you want?
Listed after 3 weeks.
Okay. What is the reason for adjournment?
Due to main counsel is out of station, so
Okay, some is Miss so some is that the learned conducting counsel, Mr. Who is out of station?
Mr. B. Arun.
B. Arun is out of station and prays for adjournment. The prayer is allowed. This matter after 3 weeks. Okay.
Much of
May I please, Lordship?
Yes.
Your Lordship, I beg to mention item number 15.
Item
15. Here, the leading counsel is not keeping well, so matter may be adjourned for today and fixed after 3 weeks. I am
You
on
are
behalf
Mr.
of D. Kamduk,
You are Mr.
M. Ratan.
appearing on behalf of, oh, sir, some is that Mr. The leading counsel, Mr. Dugma Kamduk is out of station and pray for listing this matter after
3 weeks.
3 weeks. The
There
prayer
is-
is allowed.
There is interim, Your Lordship.
List this matter after 3 weeks. The interim order passed earlier shall continue till the next date. Okay. Yes.
Masuk.
May I, my lord?
Yes.
I beg to mention item number 30 and 31.
Item
30 and 31. My lord, this matter may fix up to 3 weeks, my lord.
30 and
31.
you are for?
I am for the respondent.
Who is for the petitioner?
I have no. I have taken the consent of petitioner.
Okay.
Waipango.
You are Mr.
T Taggu.
Mr. T. Tagum.
T Taggu.
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 Learned counsel for the respondent number?
I am for the respondent.
Respondent.
Yes.
With the consent of the learned counsel for the petitioner, prays for listing this matter after 3 weeks.
After 3 weeks.
The prayer is allowed. List this matter after 3 weeks.
And
Okay.
my lord, and item number 33 and 34.
33 and 34.
Yes, my lord.
Yes.
I am for the petitioner here, my lord. I have taken the consent of respondent.
Okay, Mr. Titagu,
Yes.
Learned Counsel for the petitioner, with the consent of the Learned Counsel for the respondents. Praise for listing this matter after 3 weeks.
3 weeks.
The prayer is allowed. List this matter after 3 weeks.
Yeah.
Okay.
Much obliged.
My lord, I like to mention unlisted matter. Yes. Criminal petition 195, 2023, my lord.
This is criminal petition.
Yes.
About what?
Yes, my lord.
What is this matter about?
Coercing, my lord.
Hmm?
Coercing,
Coercing.
FIR coercing.
What is the offense involved?
My lord, there was some mistake there. I may be allowed to next this listed. I may be allowed to withdraw.
Oh, you want to
That reason-
withdraw
Yes, yes. That reason today I mentioned.
today?
Yes.
Okay.
Lordship, I beg to mention item number 3.
Item 3.
I am for the respondent.
You are for respondent.
Yes,
What do you want?
3 weeks time, Your Lordship.
Okay. Who is for the petitioner?
I have taken,
Have you informed?
Gungam Jini, yes, I have taken the consent.
Okay. You are Mr.
A Gamre, on behalf of D Pangin.
A.
Gamre,
Gamne, appearing on behalf of
D Pangin.
Mr. D. Pang, Learned Counsel for the respondent, with the consent of the Learned Counsel for the petitioner. Praise for listing this matter after
3 weeks.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
And also, Your Lordship, item number 5.
Item 5.
Item number 5, my brother Pangil was to file
Not yet filed, it appears.
Yes,
Affidavit reply.
affidavit in opposition he was supposed to file.
Hmm.
1 week may be granted and may be listed accordingly.
Okay.
With or without affidavit. I have a word with him.
Okay. You are Mr.
A Gamre.
appearing on behalf of Mr. D. Pangin, Learned Counsel for the respondent. Praise for further 1 week time to file affidavit in opposition. Okay.
Lordship, and also item
Just a
number.
minute. Mr. T. Tara, Learned Counsel for the petitioner is also present. Please pray, list this matter after a week.
1 week.
After a week. Okay. Okay.
Item number 21.
21. Yes.
I'm on behalf of the petitioner C.W. Mantau.
What do you want here?
I want to mention for 3 weeks time. 3 weeks.
Why?
Because the main council is out of station. And also there's the application, leave for application.
Hmm?
The main council is out of station and he has filed leave.
Okay, Mr.
And also Lordship, there's an
Just-
interim order.
Hmm?
Interim order is also there.
Okay. Mr. Usnema, appearing on behalf of C.W. Mantha. Praise for submits that the leading counsel is out of station. And pray for adjournment. The prayer allowed. List this matter after 3 weeks. The interim order passed earlier, so continue to the next date. Okay.
May I please, Your Lordship?
Yes.
I beg to mention item number 6 to 10. These are analogous matters. We were hoping to get a disposal today, but the respondent has filed additional affidavit in the midst of the thing, so we need some time to get instructions. Can it be taken up after 1 week?
Okay.
There is
Let's pray for by the Learned Counsel for that. It is your for petitioner.
petitioner.
Petitioner, Ms. Nikita Dangan. List this matter after a week. Okay.
Lordship, there is an interim order also.
Have you informed the other side?
Yes, yes.
Okay. The interim order passed earlier shall continue till the next date. Okay.
Obliged.
My lord, My lord, yes,
Yes.
unlisted matter will be listed on tomorrow, my lord. Yes,
Tomorrow?
Yes.
Okay.
May I, Lordship? Lordship, I beg to mention item number 32. With the consent from the other side, the matter may be listed after 2 weeks, Lordship.
Okay. You are Mr.
B type or yeah.
Mr. B. Taipodia, non-counsel for the
Petitioner.
appellant with the consent of the other side. Prays for listing this matter after
2 weeks, Lordship.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention one unlisted matter for listing it today.
What
The,
is this matter about?
Matter is with regard to anticipatory bail. Anticipatory bail.
Okay.
Highly obliged.
Yes.
May I please, Your Honor?
Yes.
And I beg to mention item number 22.
20?
22. In this case, Your Honor, I'm appearing on behalf of the respondent, standing counsel for the Guwahati High Court, Mr. Mukherjee, sir.
Hmm?
I'm appearing on behalf of Mr. Mukherjee, sir. However, we've been informed by the petitioner's advocate that he won't be able to be present today because of some personal difficulties. So on behalf of the petitioner, this matter may be adjourned for today and fixed on 19th of July.
Okay. You're appearing on behalf of?
Mr. Mukherjee, standing
Okay.
counsel for Guwahati High Court.
He's, okay.
But the adjournment is being made on behalf of the petitioner.
Is prayed for by Miss,
UI Butcher.
appearing on behalf of Mr. Mukherjee, Lion Senior Counsel. No, counsel for the petitioner, with the consent of the petitioner is also
The petitioner is the one who
Okay.
telephonically
Consent of-
informed us that
okay.
he won't be able
with the
to
consent
present.
of the petitioner, Lion counsel for the petitioner. Prays for listing this matter on
19th of July,
19 of 19/7.
07.
The prayer is allowed. List this matter on 19 accordingly. Okay.
Your Honor, also I'd like to mention another unlisted matter, criminal appeal number 14 of 2024, to be taken up on 17th. It was last listed on 22nd of May, and it has already been 4 weeks.
So when you want this matter?
On 17th,
17.
day after.
Have you
tomorrow.
filed?
Yes, Your Honor, I'll give the memo right now,
Okay.
if Your Honor may allow.
Okay. 17.
17th,
Okay.
we'll be obliged.
Mention the date in the mention memo. Okay.
Yes.
Your Lordship, I beg to mention item number 17 and 27.
17.
Yes, 17 and 27. On behalf of my senior counsel, Sring Gyatso.
You're for the petitioner.
Yes, Your Lordship. Your Lordship, this matter may be fixed next week.
Next week.
Yes, Your Lordship.
Mr. You're Mr.
L. Jonathan,
Lion counsel for the petitioner. Prays for listing this matter
next week.
after a week. The prayer is allowed. List this matter after a week. Okay. 17. And 27, what is this matter? Immunity.
It's the same matter, Your Lordship.
Same.
It's connected matter.
Okay. 27 also, huh? Yes.
I would like to mention one pending matter, writ petition, Lordship. There is urgency in the matter. This with regard to this land compensation. Matter will be exported tomorrow.
Okay. 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 This appeal stands dismissed. And interim order, if any, stands vacated. The IA, in IA also, you're right. In view of the order, so the IA stands dismissed. Disposal, huh? Okay. Yes. So that's- Item 2.
May it please your lordship. May it please your lordship.
Yes.
Lordship. Yes, lordship. I prefer this application under 482 of Bharatiya Nagrik Suraksha Sanhita for granting pre-arrest bail, lordship. An FIR has been lodged against me, lordship, on 26 November 2023, lordship, and accordingly, notice under 41A has been served upon me. But lordship, due to the general election, I could not appear before the Namse police station, lordship, and therefore I have given the reply also, lordship. Now, lordship, now I'm intending to comply with the cooperate with the police, lordship. Therefore, I need some protection, lordship. So, lordship, regarding my allegation, lordship, may I read the FIR, lordship?
Just a minute, just a minute. You
yes,
filed this?
Yes, lordship.
482, number 7. The register offense registered under which section?
354A, lordship, which is section 75 of Bharatiya Nyaya Sanhita, that is sexual harassment, lordship.
No, how it is? Let us see the FIR.
Yes, lordship. FIR is page number 18, lordship, type copy.
Page 18.
Yes, lordship.
This was filed on? The FIR was filed on?
2nd December 2023. lordship.
This is prior to the
Prior
Bharatiya Nyaya
to the
Sanhita?
implementation of BNSS.
Yes.
Yes.
Yes,
So why you
lordship.
have written this? 75, under section 75. What is the 75?
75 is also, lordship, the sexual harassment, lordship.
No, where it is registered?
No, it is not registered under 75. So it is
And why you
registered
have inserted this?
lordship, because after new law, lordship, sexual harassment section is 75, lordship, in BNS 2023, lordship. This is
What is 75? What the 75 says? The provision under 75?
yes, lordship.
BNS?
Yes, lordship. May I read, lordship? Sexual harassment, lordship. May I read, lordship?
Let us see, first see the registered section. FIR registered, received
Yes,
on, come to 19, page 19A.
Yes, lordship.
Where do we find this 75?
It was not registered under 75, your lordship. Perhaps 75 it is corresponding to section 354A. But your lordship, so far my understanding is concerned, the incident has happened prior to the enforcement of BNSS.
354A only.
Yes, it has to be deal with the old code, not by the new code, your lordship.
Yes.
So the section was inserted by the petitioner itself, your lordship, not by the investigation agency. Investigation agency has booked under section 354A, and it is, your lordship, as per the repeal and saving clause of the new Sanhita,
Yes.
the old code will prevail, your lordship.
So this 75 is corresponding with the section 354A.
Yes, lordship.
Now, your lordship, the issue here is the court has to deal with whether it will be maintainable or not, because they have invoked the 482 of the BNSS.
Yes.
Which is corresponding to 438 of CRPC old code, your lordship.
Why you have inserted this 75 when it was registered under 354 only?
Yes, lordship. Because this is the new law, lordship, therefore I inserted, because
It was registered under old law only.
354A, lordship. Registered under 354A, lordship.
Yes, but why
Yes,
you have
lordship.
inserted this 75?
Because Lordship, this is the similar section, Lordship. This is new law, therefore I inserted, Lordship. As this new law has been implemented, Lordship, therefore I inserted, Lordship.
Well, have we dealt with the section 75 in the body of the petition?
And Lordship, I would like to apprise this, Your Lordship. Your Lordship, earlier they have moved the bail application. The bail application. Only that the affidavit was not sworn by the applicant itself. They have withdrawn this bail application. It was filed under 438 CRPC on earlier occasion. They have
There
withdrawn
was
it,
a typographical error, Lordship.
which they have not stated in their bail application. And secondly, Your Lordship, whether this bail application will be 438 or 438 of the CRPC, that has to be looked into by going into the saving and repeal clause of the CR or BNSS, Your Lordship.
Lordship, Lordship, as per Article 20, Clause 1 also, Lordship, I can avail
Now
the
you see.
Lordship.
Now you see,
Yes.
you have inserted
Yes,
this 75 of BNS,
Yes.
but then after implementation, you have filed this under 482 again.
Yes, Your Lordship. Now, Your Lordship, we have to see the saving clause because, Your Lordship, this will not be the only application. Later on also, Your Lordship, there will be a great, Your Lordship, confusion regarding invocation of the BNSS provision. Because we have to go through properly through the provision of the BNSS saving and repeal clause, Your Lordship, wherein the legislature has intended that the procedural law will not have retrospective effect, Your Lordship, so far as my understanding is concerned. Otherwise, Your Lordship, if the same is not expressly expressed by the legislature, Your Lordship, it will have a retrospective effect, no doubt. But here, the legislature has expressly, Your Lordship, mentioned in the saving and repeal clause, it says the pending, Your Lordship. And the offense was committed in the year back 2023, December, Your Lordship.
Okay.
And the section 75 was inserted by the petitioner itself, not by the investigation agency.
Okay, but then of course, this application on the 482.
Yes, Your Lordship. Your Lordship, if Your Lordship allow, I would like to, Your Lordship, read out the repeal and saving clause, Your Lordship, for better understanding of whether this application will be maintainable or not.
Saving clause of
BNSS, Your Lordship, 531. 531 of BNSS, Bharat
BNS. Do we have
Nagrik
the
Suraksha Sanhita, BNSS.
section?
Your Lordship, 531. May I read, Your Lordship?
Just a minute.
Okay.
Yes.
Lordship, 531.
Yes.
Subclause 1, subsection 1. The Code of Criminal Procedure 1973, 2 of 1971, hereby repeal. 531, Your Lordship.
Yes.
Now, Your Lordship, may kindly see the subsection 2. That is the intendment of the legislature. Otherwise, Your Lordship, the procedural law is always have a retrospective effect, Your Lordship. Notwithstanding such repeal, A, if immediately before the date on which this Sanhita come into force, there is any appeal, application, trial, inquiry, or investigation pending, then such appeal, application, trial, inquiry, or investigation shall be disposed of, Your Lordship. It says disposed of, continue, held or made as case may be, in accordance with the provision of the Code of Criminal Procedure, as in force immediately before such commencement, herein is referred as said code, as if this Sanhita had not come into force, Your Lordship. Now, Your Lordship, this subclause may have two interpretations, Your Lordship. If we see it disjunctive, if we read it disjunctively, Your Lordship, now, Your Lordship has seen the word pending shall be disposed of. Investigation cannot be disposed of, Your Lordship. investigation can be completed, your lordship. Now, with the pendency of the investigation, it can be safely said that if investigation is pending, then trial is also considered to be pending, your lordship, pertains to that offense, your lordship. Otherwise, if we read it disjunctively, your lordship, if investigation is complete prior to the commencement of this new Sanghita, then after commencement of this Sanghita, that if investigation is completed, then it has to be considered by, it has to be read by under BNSS, your lordship. That will one of the interpretation. The other would be, your lordship, if investigation is pending and the legislature has used the word be disposed of or continue. Investigation, your lordship, doesn't dispose of. Investigation concluded or investigation will be disposed of with the end of culmination of the trial, your lordship. The investigation of certain offense. But if we read it disjunctively, your lordship, then there will be a lots of confusion, your lordship, in my humble understanding. Because it doesn't say the pending before the court. It says pending. So if it is pending, then earlier code will be applicable, your lordship, as if the Sanghita is not in force. Then in such case, they have to invoke 438 of the CRPC.
No, 482.
May it please your lordship. Lordship is very much relevant, lordship. Article 20 clause 1, lordship. There are two cases, lordship. Kedarnath versus state of West Bengal and Ratanlal versus state of Punjab, lordship. On those cases, lordship, the Honorable Apex Court clearly mentioned that the court can give the punishment whichever is lower, lordship. Therefore, lordship, the accused can be punished with maybe both laws, lordship, the present or previous laws, lordship.
Your lordship, this so far as IPC is concerned, the IPC is a substantive law which will not have a retrospective effect. It will always have a prospective effect. And so far as procedural law is concerned, it will always have a retrospective effect unless it is contrary to the intendment of the legislature. Now, your lordship, the subclause A says dependency, your lordship. If investigation is pending, your lordship, and word used is disposed of and continued. Investigation cannot be disposed of, your lordship. Investigation can be completed, no doubt, but it will be disposed of with the culmination of the trial itself, your lordship. And your lordship, if BNS is made applicable in this case, then all the procedural law will be applicable in, although it has been registered under IPC, it will be applicable for the entire step of the case, your lordship. 187 will be applicable in place of 167.
So that means during this period, during the pendency of the investigation,
Yes, your lordship.
this law applied.
Yes, CRPC with
Since it was still under pending
investigation. Yes, your lordship.
investigation,
Yes, your lordship.
so this will apply the
Code of
CRPC.
Yes, your lordship. In fact, your lordship, this provision requires judicial interpretation, your lordship, because
Counsel for the petition, have you gone through
Yes, lordship.
531? 531, kindly go through 531.
Yes. Yes, lordship.
Yes. What do you have to submit? Huh? What do you have to say?
Lordship is correct, but lordship, my submission is regarding Article 20 clause 1, lordship.
Article?
Article 20 clause 1 of Indian Constitution,
What?
lordship. So
What?
there are two judgments of Apex Court, lordship. Kedarnath versus State of West Bengal and Ratanlal versus State of Punjab.
What it says?
Says, lordship, the honorable court may give punishment to the accused from, it may be the present law or the previous law, but whichever is lower, Lordship. Whichever is lower punishment, Lordship. Therefore, we can.
We are not on IPC. At the moment, we are not on IPC.
Okay, CRPC.
Your application, regarding your application, file under 482.
480.
Yeah, of
480.
BNSS.
Yes. BNSS.
See 531 clause 2A. Read it. I think you have to amend.
Clause 1, Lordship.
Hmm?
The committee of this one, Lordship.
And your
Pardon,
Lordship,
Lordship.
there is no requirement of going to the Article 20 because the
Yes,
repeal
yes,
and saving
that's
clause
good,
is
that's
very
good.
clear.
We are on IPC.
Yes, and your Lordship, even in BNS, your Lordship may kindly come to the provision of BNS. It is very clear, your Lordship, 358 of the BNS, your Lordship. So, BNS, Bharatiya Nyaya Sanhita.
Three.
358, your Lordship. Lordship.
Yes.
Yes, your Lordship. Repeal and saving clause. The Indian Penal Code is hereby repealed. Subsection 2. Notwithstanding the repeal of the code referred to the subsection 1, it shall not affect. Now, this is the intent of the legislature. The previous operation of the code so repealed, or anything duly done or suffered thereunder, or any right, privilege, obligation, or liability acquired, accrued, or incurred under the code so repealed, or any penalty or punishment incurred in respect of any offense committed against the code so repealed, or any investigation or remedy, your Lordship, in respect of such penalty or punishment, or any proceeding it says, investigation or remedy in respect of any such penalty or punishment as aforesaid, and any such proceeding or remedy may be instituted, continue, or enforced, and any such penalty may be imposed as if the code has not been repealed. Notwithstanding such repeal, anything done or any action taken under the said code shall be deemed to have been done or taken under the corresponding provision of the Sanhita, your Lordship. The mention of the particular matter in subsection 2 shall not be held to prejudice or affect the general application of section 6 of the General Clause Act 1897 with regard to the effect of the repeal, your Lordship. Your Lordship, the substantive law will always have a prospective effect, your Lordship.
Yes.
And the offense was committed prior to the enforcement of this new code. So it will be treated as if it has been committed under IPC.
Yes, Mr. Learning Counsel for the petitioner. Either you take time or withdraw.
I need some time, Lordship, to clear this, Lordship. Maybe fix tomorrow, Lordship, so that I can prepare the matter.
You want
Lordship.
this matter to be
Maybe
listed
fix
tomorrow?
Lordship.
Hmm?
Yes, Lordship.
Tomorrow?
Yes, Lordship.
Okay, please prayed for by the Learning Counsel
Yes,
for the
Lordship.
petitioner. List this matter again tomorrow.
Yes.
Okay.
Deeply obliged.
Yes.
Yeah, Lordship. Lordship, this matter will be adjourned for today. My senior counsel is out of station.
You are for?
Petitioner.
Petitioner?
Yes, madam.
You are for petitioner?
Yes, madam.
Appear on behalf of?
C. Modi.
C. Modi?
Yes, madam.
So, but the state has not yet filed affidavit of opposition.
Your Lordship, I'm appearing for the respondent number 326. And we have filed our affidavit, Your Lordship.
3 to 6, you have filed?
Yes, Your Lordship, we have filed.
Okay, and then probably who has not filed? 8. Have you filed? Okay. Counter affidavit not yet filed. on behalf of respondent number two, who is for three, you are for 326. You have filed.
Yes, Your Lordship, I have filed, this affidavit has been filed for respondent number 6, Your Lordship.
Not on behalf, respondent number three, who is representing, you are representing
three is-
respondent number three also.
Yes, Your Lordship, state respondent.
So what about the respondent number three is not filing any affidavit in opposition?
Yes, Your Lordship.
Filing?
Well, I will be filing, Your Lordship.
Okay.
I will need some time for.
Hmm.
3 weeks time may be granted, Your Lordship.
Okay. You are Mr.
M level.
Land counsel for the petitioner is present. Stop. Miss. Please Sangeeta, land counsel for the respondent numbers 3 to 6. Praise for further 3 weeks time to file affidavit in opposition on behalf of respondent number 3. Stop. Mr. J. Ginny, land counsel for the respondent number 8 is also present. No, you are not filing. Okay. Okay, please pray for by the land counsel for the respondent. List this matter after 3 weeks. Okay.
Obliged.
We have filed our affidavit, Your Lordship. I'm for 1 and 3, Your Lordship.
You are for respondent number 1 and 3.
And 3, Your Lordship.
Have you filed?
Yes, we have filed, Your Lordship.
Okay. So they were to file affidavit in reply. Petition, no one appeared.
No, Your Lordship.
No one appears on behalf of.
In fact,
The
on the
petitioner.
last occasion also they were absent, Your Lordship.
Okay. On call, huh? So you have, Mr.
Vairam, Your Lordship.
Land counsel for.
1 and 3.
Counsel for-
1 and 3.
Phone number 1 and 3 is present. Staff. In absence of the land counsel for the petitioner, the matter stand adjourned. List this matter after 4 weeks. Okay.
Obliged. Here, Your Lordship,
Okay.
Learned
No
Additional
one
Advocate
appears
General.
on
No, Your
behalf
Lordship.
of the
They,
petitioner.
they were to appear through the VC, Your Lordship.
Okay, on call, huh? In absence of the counsel for the petitioner, list, the case stands adjourned. List this matter after 4 weeks. You are
Next week,
for-
Your Lordship.
Hmm?
Next week, Your Lordship.
Next week?
Yes, Your Lordship.
Okay. Is prayed for by the land counsel for the rest. You are for respondent number?
Both respondent, Your Lordship.
Hmm?
Both respondent, Your Lordship.
Okay. Is prayed for by Mr. His name, land counsel for the respondents. List this matter after a week. Okay.
Obliged, Your Lordship.
May I, Your Lordship?
Yes,
Your Lordship, matter may be possible for time being, Your Lordship.
time being.
Yes, Your Lordship.
Okay. Time being, huh?
Yes, Your Lordship. Much.
None appears for the parties on call. Case stand adjourned. List is matter after 3 weeks. Okay. Yes, my lordship. Yes. That is petition, telling me interim suspension order dated first December 2020.
Yes,
Interim
Your
orders annexure 1, page number 18, Your Honor. Through this order, I have been suspended on the dated first December 2022, Your Honor.
Just a minute, huh? You are for the
Till
petitioner.
that, no review has been taken place, Your Honor.
Okay. Who is for the respondent?
Respondent is Education Department, Your Honor.
I'm appearing on behalf of Education Standing Council for Education Department. Your Honor, Tabatang is appearing on in court number 2, Your Honor.
Okay. Let him come.
Yes, sir.
Pass over for the time being, huh? This also.
May I please, Your Lordship? I'm sorry, Your Lordship, I'm preparing in item number 16, Your Lordship. I have overheard the item, Your Lordship. I'm appearing for item number 16, Your Lordship.
16?
Yes, I'm appearing for the government respondents, Your Lordship.
You, in 16, you are for respondent.
Yes, government official respondents.
Not 16, what do you have written? Okay, these are present may be recorded, huh? In absence of the Honorable Counsel for the petitioner, the matter is stand adjourned. List this matter after 3 weeks, huh? Okay.
All right.
Yes.
Item number 19.
19.
Your Lordship, the petitioner were directed to take steps, Your Lordship, on the earlier occasion.
Yes.
Please step upon respondent number 3 on 6/5/24.
Still awaited.
Then in that case, Your
Medic
Lordship,
cards still awaited, huh?
what is that?
So respondent number 3 is a private respondent.
Private father of the deceased person.
Okay, and so
Maybe awaited, Your Lordship.
in view of the office note dated 11/7/2024, the matter stand adjourned. Just a minute, huh? There's some steps taken. No, right like this. Huh? The office note dated 11/7/2024 reflects that the notice upon the respondent number 3 is still awaited. In that view of the matter stands adjourned. Release this matter after 3 weeks. He's present, huh? Mr. Theatre, Lana Council, sorry, Lana PP, additional PP, he's present. Huh? Okay.
Okay. Deeply obliged, Your Lordship.
No one appears on behalf of the petitioner on call. Start. Huh? The office note dated 12/7/2024 reflects that the service in respect of the respondent number 2 is still awaited. In view of the above, the matter stand adjourned. List this matter after 3 weeks. Okay.
Item number 24.
My please, my lord.
Yes.
In this matter, I have taken a step, but service report is avoided.
Okay. Mr. D. Lajilana, counsel for the petitioner, submits that he has taken steps. However, the service report is still awaited. In view of the above, the case stand adjourned. List this matter after 3 weeks.
After 2 weeks.
After 2 weeks. Okay.
Not so late.
Mhm.
My lord, here in this case, on the last occasion, I was directed to file on IA for correction of cause title. Accordingly, I have already complied. So this time, my lord, notice may be issued.
There's a POXO matter, your lordship.
The same suspension order before this honorable court, and this our honorable court has set aside the suspension order of the other accused who were involved in a paper leaking fiasco, Your Honor. May I place the order of this our honorable High Court, Your Honor, where the suspension order has been set aside, Your Honor.
Yes, Mr. Tugum, you were
My lord,
directed to obtain instruction,
my lord, yes.
probably.
My lord, from, as per instruction, my lord, admittedly, no review has been done. My lord.
Okay,
So in view of the matter, my lord, this 90 days, the review has to be made within the 90 days. Since it has not been done, my lord. I think,
it's a covered
the
case.
cover up case, my lord.
Okay, so we'll pass order then.
My
Yes,
lord.
sir. And Your Honor, top of that, petitioner has already been retired 1 month back, Your Honor.
All right, my lord, that suspension.
Yes, sir.
Okay, heard, Mr. You are Mr.
I'm Oppo.
Okay, I've also heard Mr. Tugum. You are Tugum, Mr. You are
Standing counsel for education department.
standing counsel for the education department. I'll pass order.
My lord.
Okay. Which chamber? You have finished.
May I please, Your Lordship?
Yes, what about this?
14, no, it's not adjournment, it's the later one. 14 was.
No, this will take time, sir.
This will take time.
This will take long time.
Okay, then I should call this meeting to.
Yes, okay. We should have called. Yes, okay. Yes, sir.
My lord, first of all, I'm sorry I could not be present when it was.
No problem.
My lord, I'll just give summary of what has been said earlier, because a long lapse of time, there may be to refresh the memory, it is necessary. Now, Your Lordship will find here the respondent as plaintiff
Just a minute.
filed a title suit. I'll give the brief fact of the case. Filed a title suit number 10 of 23 and obtained ex parte interim injunction on 22/12.
Are you giving the list of dates here? No,
No.
not yet. Okay,
I'll take Your Lordships to the respective order passed by the various courts.
just a minute.
It appears a very voluminous one, but the point involved is very short.
Okay.
Whether the plaintiff, while filing the application, whether they suppress the material and the relevant fact, that will be the question of law.
Just a minute. This is a challenge to the judgment passed by
the appellate court. Well, the first of all, I'll take Your Lordships to the impugn ex parte order passed by the trial court.
Okay.
Now, against that, we have filed an application to vacate that order under Order 39, Rule 4. That was rejected. Against that, we filed an appeal. The appellate authority also rejected it. Now, Your Lordship will find both the trial judge as well as the appellate forum, well, did not go into the legal question which they ought to have gone. And in a routine manner, they passed an order without giving any reason. Now, as Your Lordship is aware, in case of ex parte injunction, my lord, before the court, there is nothing except the plaint. Now, in the plaint, you are required to give the utmost good faith, all the truth, nothing but the truth. Now, because the learned judge will be guided by the plaint only, because the day when you move it, there is nothing, no evidence, nothing. Now, if you give the truth in the plaint, and the learned judge is required to go to that only, and so far injunction is concerned, Your Lordship is well aware, is an equitable relief. When you come to the court to get an equitable relief, it is your bounden duty to give the true facts, should be narrated, what is gospel truth and nothing else. Now here, Your Lordship will find, in the plaint, my lord, the fact is there was an election on 14/10/2022. Now, that election, my lord, is required to be preceded by a notice under Article 29 of the constitution of the PPA, that is the People's Party of Arunachal. Now, in the plaint, they did not say that the Article 29 was meticulously followed. Now, once you do not follow that, well, the case will fall flat. Now, exactly this thing happened here, and both the trial judge as well as the appellate judge did not consider at all that. The many a times, different high courts and the appeals court has passed an order that if the material fact has been withdrawn from the court that amounts to committing fraud, and any order obtained in that way is a fraud played in the court, and therefore any order obtained which is having the color of fraud, that vitiates everything. And therefore, my lord, the order enters into nullity, and that order cannot be given effect to any point of time. So out and out, it's a case where ultimately your lordship will find a case of remand by setting aside the order passed by both the forum. Now, I'll take your lordships to the order passed by the trial judge at page 166. Before that, my lord, I will take your lordship to the plaint, because your lordship will have to look at plaint first.
Yeah.
Which your lordship will find at page 74. Page 74, your lordship will find the plaint.
Yes.
Your lordship will find the cause title, suit under section 9 of the Code of Civil Procedure, read with section 34, 38 of the Specific Relief Act, 1963, for a decree declaring the title in favor of the plaintiff, and for a decree declaring the election result of defendants dated 12/11/2023. Now, in a civil proceeding, as your lordship understands, my lord, the plaintiff will have to stand on their own feet. They cannot take advantage of the weakness of the defendant. My lord, in this, both the trial judge and the appellate forum, what they did, my lord, they have scrutinized the case in the reverse angle. My lord, they tried to see whether the defendant has succeeded to establish their case, which is against the all principles of law. When the plaintiff will have to stand on their own legs, they are saying that the election was held on 14/10/2022. Now, if the election was held on that date, whether this election of president was approved by the chairman, which is required to be done under Article 11, Article 29, Article 13. My lord, I'll take to your lordship those provisions of law. Now, here in this case, your lordship will find both the forum has proceeded in the reverse gap. Your lordship kindly see the averment what made in this plaint and whether they have stated the material facts. My lord, para 1, I am skipping. Para 2 also your lordship can skip. Now, let us come to paragraph 3, my lord, at page 83. The facts are narrated by them. The plaintiffs most respectfully submits. Para 3 onwards, my lord.
Okay.
At page 83, your lordship will find.
Yes.
That plaintiffs most respectfully submits that the state executive meeting was held at the PPA. Your lordship kindly mark the word state executive meeting was held at the PPA office. PPA means People's Party of Arunachal. Dated 24/9/2022. Where all the signatories like state executive members, district presidents, women wing executives, and state youth office bearers were present, and the House present was unanimously decided to adopt following resolutions as such. Article 13, PPA Central Working Committee shall be discussed in detail by the party executives. The House unanimously decided to do away with the post of CWC chairman, as it has been found redundant, regressive, and contradictory to the spirit of party policies and programs over various crucial issues of state importance like so and so, so and so. Henceforth, the party shall be headed by the president. The House also decided to fix the basic qualification needed for the post of the party president. It was decided that anybody vying for the post of the party president should have been an active member of the party for a minimum of 3 years. The House was of the unanimous opinion that the party, Your Lordship may skip this part. Then, Your Lordship may see paragraph
This
4.
was filed by,
Beg your pardon. What he has asked. No. Is filed by these two plaintiff, my lord, at page 75. The President Sri Khafa Bengia and Kalyang Jerang, Secretary General, President and Secretary General.
against,
Against the
okay.
my lord, respond number 1 to 33, no? 22.
Yes.
All the respondents, those are chairman and executive members. Then para 4, Your Lordship may kindly come. The plaintiffs beg to submit that as the election was due, as the term is its previous executive members was over, hence once Sri Taba Tagar, a member of PPA, was appointed as returning officer for conducting election of PPA for the term 2022-2025. Accordingly, the returning officer issued a public notice through newspaper for nomination paper by notification dated so and so. The plaintiff humbly submits that the election was held on 14/10/2022 and the results were declared on the same date. Sri Kafa Bengia elected unopposed as the president and Sri Kaling Jarang was elected unopposed as the Secretary General of PPA for the term 2022-2025. Now, Your Lordship will not find there was no averment that the People's Assembly was held any point of time. People's Assembly, as contemplated under Article 29, then Article 11, Article 13. The People's Assembly will held a meeting, and then, my lord, when the election will take place, he is the person who will approve everything. And in the plaint, Your Lordship will not find all this, no averment at all. Now, apart from that, if Your Lordship look at Article 29, Your Lordship will find you will have to give 1 month notice prior to holding the election. Now, there was no notice any point of time was served. And these are the very material and relevant fact which has been withheld from the plaint. If these facts were
no averment with regards on the compliance of
Article
29.
29.
29 of
29 of the melody, I will take Your Lordships to that. It is better to see that also. Please keep me. Your Lordship may see page 265. Unless we look at that, my lord, the matter will not be very clear. Your Lordship may look at 265. Good. My lord, Your Lordship may turn to page 268, Article 29.
This is the constitution of
This is the Constitution of People's Party of Arunachal. is the regional party.
Yes.
Now, if your lordship look at Article 29 at page 268. Your lordship take the small book, it will be easier, I think. That book just now we have furnished.
Yes.
It will be easier if your lordship look at that. Article 29 at page 20. Let's go again. It reads like this.
Yes.
The party constitution shall be amended only by the People's Assembly. The notice or proposals for amending the constitution shall be given 1 month before the said assembly. Now, my lord, their case is that on 14/10/2022, there was a meeting and there was an amendment also. And by virtue of that amendment, the post of chairman was withdrawn. My lord.
Otherwise, the provision under Article 29.
Yes.
The party shall be, the constitution shall be, sorry.
The party constitution shall be amended.
Amended only by the people's.
People's Assembly.
That's the People's Assembly.
My lord. Now, the People's Assembly must be there. And before that, the notice of proposal for amending the constitution shall be given 1 month before the said assembly. Now, nothing all these things happened, my lord, and no averment in the plaint. Had this been stated in the plaint, my lord, this trial court as well as the appellate court would not have passed any ex parte injunction order. Because these are the things, my lord, this is a mandatory provision you must follow meticulously. Once you fail to do that, entire thing will go away. Then the meaning of People's Assembly, my lord, your lordship will find Article 10. Your lordship kindly come to Article 10. That has been defined what is People's Assembly.
Article 10, page?
Page, my lord.
In the booklet?
Article 10. Page 10. Page 10, down below, Article 10. People's Assembly. The Supreme, as your lordship got it.
People's Assembly.
The supreme organ of the party for the whole state shall be the People's Assembly. The conference of the People's Assembly shall be convened by the executive ordinary once in every 3 years. An extraordinary People's Assembly shall be called by the state executives when it is demanded by 2/3 members of state executive. The date and venue of the conference of the People's Assembly or of the extraordinary People's Assembly shall be decided by the state executive at a meeting specially called for the purpose. Now, 4 is very important, my lord. The People's Assembly shall be composed of delegates elected by the block, district, and city executives, 10 from block and 15 each from the district and city. The member of the State Assembly and executive president and general secretary of district, city, and block executives, Anchal chairperson, so and so, have the right to participate as full delegates in the People's Assembly, whether regular or extraordinary. Now, your lordship will find in the plaint they did not say all these things, that the meeting was conducted and the People's Assembly conducted that meeting, and ultimately election was held. And if the election was held on 14/10/2022, that will invariably have to be approved by the chairman. Now, that approval is also not there. So therefore, my lord, this is the crux of the case. And if there is a substantial violation of Article 29, read with Article 10, my lord, that's the entire thing goes on that. On the basis of that, my lord, how the, my lord, when the ex parte injunction was given by the trial court, he did not have all these materials before him because these averments are missing in the plaint. Now, once these averments are meeting in the plaint, I fail to understand how the learned judge derived his satisfaction to say that election which held on 14/10/2022 is a valid election. So now he could not have passed that order, that too, my lord, ex parte injunction order, without making him satisfied that the mandatory provision of the Constitution were followed. Rather, my lord, I will take your lordship the finding of the learned judge is a peculiar finding given what is stated that they may not have followed the procedure of law, procedure of the Constitution, but that will not make the election invalid. But I do fail to understand how that finding can be given. Even such finding was so illegal, we filed an application to vacate that order. My lord, the same thing, same order was passed. We carried the same before the appellate authority. Appellate authority also, my lord, he has further misled himself, saying that there is no error by the, there is no intentional error by the plaintiff, not stating all these things. What does it mean? How your satisfaction comes? You will have to, when you pass an ex parte injunction order, it's an, my lord, the Supreme Court has said, when you pass an ex parte order, it is only under a very, very exceptional circumstances. Now, what is the exceptional circumstances here? My lord, you held an election on 14/10/2022. By misrepresenting the court, you did not say all these things that the Article 29 will have to be complied with. You kept yourself mum. You did not say, disclose all these things before the court. Ultimately, court was misguided. And I will not, my lord, only say that the plaintiffs are only responsible. Even the court is also responsible. The court has a duty in terms of Section 30 of the CPC, your lordship will find, it is the duty of the court to see that if there is a the mandatory provision of the Constitution or any statute, it is the duty of the court to see that whether those provisions are complied. If it is not complied, my lord, how we have derived your satisfaction that it is a case where ex parte order will have to be passed, otherwise the plaintiff will suffer irreparable loss. Now, what sort of irreparable loss, my lord? Now, you have conducted an election quite illegally. What sort of right? You do not have any right. And the first of thing, when you are claiming that my right to life, right to be declared as the election was valid, that is to be decreed by the court. Now, what materials you have given? There is nothing. And the court also just in a routine manner passed the ex parte order. Now, this is so far, my lord, the very vital point I am highlighted. When your lordship may see also Article 13. Then I will go to the plaint once again. Is Article 13, page 40.
Yes.
PPA Central Working Committee. The PPA Central Working Committee is the highest decision-making body of the People's Party of Arunachal. The PPA Central Working Committee shall consist of the chairman of the PPA State Council, the President, Secretary General, General Secretaries, and 5 other members, of whom 10 members will be elected by the People's Assembly, and the rest shall be nominated by the Chairman, CWC PPA, duly recommended by the President. The Chairman, CWC PPA, shall be elected by the People's Assembly in its conference for a period of 3 years. The quorum for a meeting of the PPA Central Working Committee shall be 6. The PPA Central Working Committee shall be the highest executive authority of the party and shall have the power to carry out the policies and programs laid down with the party by the People's Assembly. The chairman CWC, this is very important, man. The chairman CWC PPA shall be approving authority of all important decision of the party. CWC shall be responsible for convening the People's Assembly. The CWC PPA shall be the final authority in all matters regarding the interpretation and application of the provision of the Constitution. The decision of CWC PPA shall be final and binding on all members or units. Now, Your Lordship, kindly see what is their case. They held a meeting on 14/10/2022. On that date, my lord, if their case is also taken into consideration, then they say the amendment took place on 4/11/2022. That means after the election took place. Now, if it is so, admitted.
Where do we find the amendment?
Yes, that, my lord, Your Lordship, kindly see the plaint at para 5, my lord, at page 85. Para 5, 6 onwards. Page 85, 85. Para 5, I'll read, my lord. That the plaintiff humbly submits that the election held on 14/10/2022 and the results were declared on the same date. Sri Kafa Bengia elected unopposed as the president and Sri Kaling Jerang was elected unopposed as the Secretary General of PPA for the term 2022-2025. Then paragraph 6. That the plaintiff most respectfully beg to submit on 4th November 2022, executive members has convened a People's Assembly and as per Article 29 of PPS Constitution, made 4th amendment of the Constitution as per resolution passed on 24/9/2022 and removed, amended the post of chairman and laid down 3 years active member eligibility criteria for holding post in executive. Now, Your Lordship, if Your Lordship look back to Article 29, any sort of amendment that will have to be through People's Assembly. Now, does it inspire any confidence from this paragraph 6? I'll read once again. That the plaintiff most respectfully beg to submit on 4th November 2022, executive members has convened a People's Assembly. Now, who is required to hold the People's Assembly, my lord? As a Lordship has seen, is the parameters given in, again, my lord, Your Lordship kindly see this Article 10, page 10. Article 10, my lord, subclause 4. The People's Assembly shall be composed of delegates elected by the block, district and city executives, 10 from block and 15 each from the district and city. Now, according to the amendment made in the plaint, that the plaintiff most respectfully beg to submit that 4th November 2022, executive members has convened a People's Assembly. It is contrary to the provision laid down in the Constitution. And as per Article 29 of PPS Constitution made 4th amendment of the Constitution as per resolution passed on such and such and removed, amended the post of chairman. Now, this will have to be done invariably by the People's Assembly, not by the executive members. How the executive members can form People's Assembly is impossible. It devours the provisions of the Constitution. So these here, my lord, I will say, this part of the statements.
No, it says that the executive member has convened a People's Assembly.
Yes.
That is as per the.
No, whether executive committee has the power to do that in terms of the Constitution.
Has convened a People's Assembly and as per Article
29. Now, my lord,
Fourth Amendment.
my lord, accepting this position is also factually correct. Is not correct, but I'm for the time being, I'm accepting. Even in that case, what will happen? My lord, they will have to serve a notice.
1 month.
Lord, 1 month notice. Now, where is that aberment? And on the top of everything, whether the executive members can convene the People's Assembly,
So
it will have to be called by the chairman.
It was on 4th November.
Yes.
Convened.
Executive
People's
members has
Assembly.
convened a People's Assembly. After the election.
And the amendment was, the amendment of the constitution as per resolution passed on.
Resolution passed on 24/9/2022. Now, who can do all these things, my lord? The chairman is the apex body. His presence is required. He will call the meeting. He will approve everything. Now, what they are saying that there was an amendment. An amendment was carried on 4th November 2022. My lord, even we accept their case also. Election was held on 14/10/2022. And in terms of the constitution, it has to be approved by the chairman. Now, where is the paper that his appointment was approved by the chairman? These are things all missing here. No averment to that in that respect. And then again, my lord, the 4th November executive members has convened a People's Assembly. Executive members have no power. Is by the, my lord, CWC only. Chairman will convene a meeting.
Okay, the meeting is to be convened by the chairman.
Yes.
Where do we find that?
That, my lord, your lordship, let us see once again the constitution. So, my lord, let us see Article 13, my lord. Article 13, page 14. Page 14, your lordship will find the PPA Central Working Committee is the highest decision-making body of the People's Party of Arunachal. The PPA Central Working Committee shall consist of the chairman of the PPA State Council, so and so, so and so. Then your lordship come to subclause 5. The chairman CWC PPA shall be approving authority of all important decisions of the party. Now, if he is the, my lord, the person who has to approve all the important decisions, then when the meeting was held on 14/10/2022, whether that the election of the president was approved by the chairman. In the plaint, all these things are missing. Obviously, my lord, because the approval of the chairman was not there at all.
Just a minute. So the meeting was held on.
That is on page 5, your lordship will find. Election was held on 14/10/2022.
Yes.
And then 6, my lord, para 6. Clause. Your lordship, for a while, can you see Article 13, subclause 6?
Yes.
CWC shall be responsible for convening the People's Assembly. Now, these are the things, my lord, these are all mandatory provision of the Constitution, and it has been flouted like anything. And that's why, my lord, the apex court time and again is saying, in the plaint, you must state the whole truth.
So this central working CWC is the executive members are not the member, not the CWC, not the member of CWC.
Yes.
But then the meeting, the CWC is shall be responsible for
convening the People's Assembly.
Not the president and the.
No, they cannot. They do not have the power.
But in the instant case,
my lord, they have called this president himself. He is called whether he has the power. Now, these are the relevant things, my lord, which have been missed by both the civil judge as well as the appellate authority. No, they ought to have made some aberrament in the plea that the Article 29, the provisions of Article 29 was meticulously complied. No such aberrament your lordship will find. And then again, my lord, if the election was held on 14/10/2022, any decision as on 14/10/2022, chairman is the approving authority of all important decision. Now, whether the appointment of the president was at all approved by the chairman, these aberrations are all missing. My lord, your lordship already know all these things, that if you are required to do certain things in a certain manner, you'll have to do in that manner only. Otherwise, my lord, then, my lord, your lordship may see at page 87, paragraph 8. My lord, the defendant at page 87, paragraph 8, that the plaintiff begs to submit that on 4/11/2023, the defendant number 2 issued a circular. Defendant number 2 is the, my lord, chairman. Issued a circular to convene a meeting by stating that the present office bearer's tenure has expired on such and such date, as per the Election Commission of India notified, dated so and so, and on 11/11/23, the same is also published in the new daily publication of Arunachal Times. Then para 9, after coming to knowledge about the circular dated so and so, issued by the defendant number 2, plaintiff number 1 issued a press notice dated 11/11/23, informing party members to refrain from taking participation in the meeting as it is unauthorized and illegal. The plaintiff begs to state that even after issuance of press notice dated so and so by the plaintiff number 1, the meeting was conducted illegally, and once a Luiki Boje was appointed as returning officer, and he has conducted the election illegally on 12/11/2023 under the behest of defendant number 2. That the plaintiff would like to apprise.
This circular was issued by coming to know.
Chairman.
Which one? Okay,
the defendant number 2 is the chairman.
Chair, he is the chairman.
So he issued the circular
My lord.
to convene a meeting by stating that.
Yes, because the term was expired, therefore he issued that circular on 12/11/2023.
This was also stating that the present office bearer's tenure has expired on 22/12/2021.
Yes.
So this the circular was issued only on 2023. Tenure expired in the on 22/12/2021. Tenure of the office bearer. So this notice was issued in the year 2023 only.
Yes, yes. Tenure was expired, my lord, in the year 2021.
So 2 years back.
Yes, but since the election was not held, they are holding the post. Now in the year 12/11/2023, my lord, they started the process of election and all. And in fact, election was held. Now this election, my lord, by virtual or ex parte order, it was stayed. And your lordship will find not only the election was stayed.
No. So this was done after all those amendments.
Yes, after our election.
Amendment was
My
done.
lord, first election was conducted by the plaintiff.
14/10/2022.
My lord, by himself, although he has no power. Now, the second election, after the term was over in the year 2021, then the chairman circulated that since the term is over, we have to go for election. Notice was served. Then, my lord, after the compliance of Article 29, election was held. Now they have come before this honorable court saying that the election which was held on 14/10/2022, and your lordship will find only two members, President and Secretary General, none other than these two.
Okay, but then this 14/10/2022 was
Yes.
held by the president and the secretary.
President and Secretary.
Okay, so
And
this was
they
not-
came unopposed.
Hmm.
That's a just made up
So-
story, my lord. Nothing in that sort had happened.
Okay.
So, now, this is the one part.
This
That is
was
their
in the-
election.
This was in the year 2022.
Yes.
But then the present chairman, the respondent number 2, he has started this proceeding in the 2023 only.
Defendant number 2, my lord, when they found that 2021 it was expired
Yes.
and no election was held.
But in between this, they have taken steps, president and the secretary,
My lord,
by
that-
holding election in 14/10/2022. So this was not under the knowledge of the chairperson.
No, the approval of chairman was never taken. That is the
Okay.
case, my lord.
Okay.
That's the reason your lordship will find going through the plane, your lordship will not find that there is a compliance of Article 29, Article 10, Article 13. No compliance. My lord, they themselves took up the
Okay,
thing.
this president and secretary has
President,
done in
secretary.
paper.
Yes. And therefore, there is no approval of the chairman.
Hmm.
Because these amendment and all that can be carried out by the People's Assembly only. Now, none other than People's Assembly, it can be amended. Now, what they are saying, that there was an amendment. Now, if you want to make an amendment, that will have to be through People's Assembly. Now, is there any amendment that People's Assembly to please the notice of 30 days was served? Plaintiff is silent about all that thing, that it was incumbent upon them to state all that there is a meticulous following of Article 29, Article 10,
At the
Article
time
13.
of holding this election in the year or on 14/10/2022, whether this petitioner or the present respondent, they were also the executive member of the PPA.
They were the member.
They were member.
They were the member.
Okay.
He was the president, but then the question is
At that
this.
time also they were president and
Yes,
secretary.
yes.
Okay, this is re-election.
Re-election by
14
himself
Okay.
without following any provisions of law.
Okay, then first they have amended.
They said that we have amended it, the
Amended.
chairman post has been removed.
Hmm.
So therefore, approval of chairman is not needed.
Okay.
Now, that
So
is
in
their
only
case.
to do away with the approval of the chairman, they have just amended.
Yes.
So amended.
Yes, that is from, my lord, on their own, they have done everything. This has got no legal validity. Therefore, they should have made some amendment in the plain. Had it been correct, that amendment was done legally. So where are those facts, my lord? How the learned judge was satisfied that after compliance of Article 29, the election was held, the amendment took place. Those things are completely missing.
Now that the amendment, they could not have done this amendment unless the approval of the chairman.
Exactly.
Okay.
And then who will held that meeting? By holding the meeting by the People's Assembly. The People's Assembly never took place. Therefore, there is no.
For amendment, for the purpose of amendment.
For the purpose of amendment. And as your lordship has seen, your lordship kindly see once again, Article 29. Who can do it? This is the only legal point involved in this case, my lord. Article 29 at page 20.
Yes.
The party constitution shall be amended only by the People's Assembly. The notice or proposal for amending the constitution shall be given 1 month before the said assembly.
Okay, who will initiate?
Yes, that is by the People's Assembly as my lord enumerated in clause Article 10. Your lordship once again see Article 10 at page 10. Article 10 speaks about People's Assembly. The supreme organ of the party for the whole state shall be the People's Assembly. The conference of the People's Assembly shall be convened by the executive ordinary once in every 3 years. An extraordinary People's Assembly shall be called by the state executives when it is demanded by 2/3 member of state executive The date and venue of the conference of the People's Assembly or of the Extraordinary People's Assembly shall be decided by the State Executive at a meeting specially called for the purpose. The People's Assembly shall be composed of delegates elected by the block, district, and city executives, 10 from block and 15 each from the district and city. Now, these are the people, my lord, who can consist of People's Assembly. Now, whether these members were there at all on that date.
So the conference of the People's Assembly shall be convened by the executive.
Yes.
Ordinary once in every 3 years. So but then this president and secretary,
they
are
can't
executive.
Executives, but then
they can
your
initiate, but
lordship,
only they can initiate.
my lord, the initiation will be by the chairman.
Initiation.
That your lordship.
Where do we find?
13, na? 13. Your lordship, can you see Article 13?
Article 13.
Article 13, clause at page 14.
Yes.
Clause 5. The chairman CWC PPA shall be approving authority in all important.
Approving is after initiation.
Yes. Then CWC, your lordship, kindly see this.
The chairman
6.
CWC PPA shall approve and shall be approving authority of all important decision of the party. Okay.
Then 6. CWC shall be responsible for convening the People's Assembly. CWC means Central Working Committee.
Headed by?
Headed by the chairman. Because your lordship, kindly see the 13.1. The PPA Central Working Committee shall consist of the chairman of the PPA State Council, the president, secretary general, general secretary. Then 2, the chairman CWC PPA shall be elected by the People's Assembly in its conference for a period of 3 years.
Where are we? The chair.
Page 14, your lordship will find it.
The chairman CWC, yes, PPA shall be elected by the people.
13 has made the provisions very clear.
13.
Then 5, 6, then 7. The CWC PPA shall be the final authority in all matters regarding interpretation and application to the provision of the Constitution. Then 8. The decision of CWC PPA shall be final and binding on all members or units. The CWC headed by the chairman, he is the authority. While the president, secretary, they cannot do anything unless the CWC comes in the fray. (13.6) is also very important. CWC shall be responsible for convening People's Assembly. It is not by anybody else, only CWC.
So CWC shall be responsible for convening the People's Assembly.
Yes.
And then the CWC is headed by the chairman.
Right.
The conference of the People's Assembly shall be convened by the executive ordinary. So see contradictory. See the Article 10(1). The conference of the People's Assembly shall be convened by the executive ordinarily once in every 3 years.
Your lordship is
But
reading.
again, the 6 says that
Your lordship is
shall
reading
be
which
responsible
which clause your lordship is reading?
So Article 10.
10, yes.
10(1).
10(1). The conference of the People's Assembly shall be convened by the executive ordinary once in every 3 years. It's not, my lord, contradictory. Here, conference of the People's Assembly, my lord, your lordship will have to see first the 10 surplus 4. The People's Assembly, how it is composed.
Delegates.
Shall be composed of delegates elected by the block, district and city executives, 10 from block and 15 each from the district and city.
Yes, but you see, the conference of the People's Assembly shall be convened by the executive ordinarily once in every 3 years. So
Now,
who initiate? Who actually initiate?
so far here the question is amendment. Amendment invariably.
No, amendment by the CWC.
Yes,
in
yes.
presence of this.
No,
So
we are-
who will initiate for amendment?
Amendment
Initiation,
is-
because you are challenging the initiation itself was not proper.
Yes, for that, my lord,
Who can initiate?
Let us see Article 29 again. Page 20.
Yes.
The party constitution shall be amended only by the People's Assembly.
Yes.
And People's Assembly is initiated by the chairman, CWC.
Okay, the chairman.
Yes.
That is 13.
13.
People's
The PPA Central Working Committee is the highest decision-making body
where
of the 13.
okay, highest, yes, that is there.
Ah.
That is there. And then 4, PPA Central Working Committee shall be the highest. Then 5, PPA chairman, CWCPA shall be approving authority.
Yes, ultimately
approving.
The approving authority.
If he is approving authority, then who will initiate?
My lord, if you look at the PPA Central Working Committee is the highest decision-making body.
Right.
Now, whatever meeting it is called for, it is by the CWC only.
Right. But
because the highest approving authority.
Yes, approval.
He is all in all, even approval.
I'm curious, just who will initiate? Who can initiate? Because the
Initiated by-
CWC is the approving authority.
Yes.
The CWC is the approving authority. Someone should be there. Then who will initiate?
Well, according to this constitution, the PPA Central Working Committee, they will do. Everything will be initiated by.
Which clause?
Otherwise, my lord, the 13, the beginning, the PPA Central Working Committee is the highest decision-making body.
Yes.
Of the
Approving
People's Party.
as well as highest decision making.
Decision making.
Yes, that agreed. But then who will initiate for this?
That's by the chairman, because he is the highest body, my lord. In the, my lord, the executive members and other members, the chairman will have to initiate all these things.
Okay, but how?
Otherwise, there will be, my lord, many.
How we will just let us come back to the Article 10.
Yes.
Of People's Assembly 10(1). The conference of the People's Assembly shall be convened by the executive ordinarily once in every 3 years.
Then my
Who
lord,
is
again,
executive? Executive headed by?
If we look at the definition of People's Assembly.
Yes.
Then in these
Then it
Article
consists
10.
of course, Joel.
Article 10, surplus 4.
Yes, consists of all the People's Assembly shall be
composed of delegates.
Yes. But then these composed of all these delegates elected by the block, district and city executive, 10 from block and 15 from district, but someone has to be there who would initiate.
Even Article 11, if you lordship look at, the state executive shall consist of president, vice president, treasurer, secretary, general secretaries, president, general secretaries of women and youth council volunteer. Then 2, the president shall be elected by the People's Assembly for the period of 3 years.
Yes.
Then 3, the president shall nominate from amongst the senior members. These are all different things, my lord.
These are different. These are different. I'm curious to know that who can initiate. Well, either the chairman or the executive headed by the chairman. Sorry, the president.
Your lordship, kindly see Article 12.
Yes.
The state executive functions of the office bearers.
Article 12,
At page 12.
yes,
President to preside over the sitting of the state executive.
right. See,
To-
it appears the president,
Then, my lord, to allocate the work and duties among the office bearers.
right.
To take part in talks with other parties and to nominate representatives from the party for the work.
Hmm.
To decide the date of the state executive meeting
Hmm.
and to convene the meeting as per rules of the party constitution.
Yes,
To appoint chairman for the various cells of the party. To conduct workers' study camps and conferences. To guide the state, my lord, these are in terms, in regard to executive meeting.
yes,
But here is, my lord, not executive meeting, but the People's Assembly. We are concerned about the People's Assembly.
yes,
Now, the People's Assembly will have to be addressed by the CWC. The head of the CWC is the chairman. Because we are not for the ordinary meeting. It is the meeting because if you want to amend the constitution, it can be amended only by the power of, my lord, the People's Assembly. Now, People's Assembly cannot be addressed by the executive members. It will have to be by the
now,
CWC.
you see, huh? These confused, no? These create confusion. If the People's Assembly is the highest body, and then the chairman is the approving authority.
My lord, if your lordship look at 12, Article 12, the functions of the state executive, they are confined to that, and that is the power of the president.
Yes, the power of the president to preside over the sitting of the
Yes,
state executive.
state executive.
Okay, so now you say come back to again. People's Assembly, Article 10.
Yes. Your lordship is in Article 10.
10, page 10.
Yes.
The conference. Now, this is People's Assembly only.
The
Article 10 is
conference
about
of the
People's Assembly.
People's Assembly shall
The
be
supreme organ
convened.
of the
That
party.
is in regard to conference.
Yes,
Conference will.
yes,
But who will initiate? The president cannot initiate that.
okay. But then how do we explain this one? The conference of the People's Assembly shall be convened by the executive.
Convene.
So
They will
now
convene.
we have seen that the executive is headed by the president.
Now, my lord, for a while.
Yes.
Now, supposing
Hmm.
the president has the power,
Hmm.
assuming that he has the power.
Hmm.
Now, whether in this particular case,
Hmm.
the Article 29 has been complied.
No, here only the question of initiation. Who can initiate? President initiated, but then he has not taken approval of the chairman.
He has not taken approval. any
But
point of
then
time.
I just who has initiated? President has a power to initiate.
My lord, so far executive
Initiate.
function, even if your lordship holds that the People's Assembly, he can initiate it. He can initiate, supposing.
President.
Supposing he has the power to initiate. All right,
Yes,
he can initiate.
Yes, yes.
But then this
That-
initiation will have to
Then
be
it's fine.
approved.
That is fine. The president initiated or can initiate, and as the president can initiate, he has initiated, but then
His
approval
action
was
by the chairman only.
approval has to be done by the chairperson of the
Yes.
CWC,
Yes.
which the president did not
Exactly.
obtain. And then that's why the Article 29
29 is very clear.
that cannot be. Because as per Article 29, it has to be amended only by the People's Assembly. And after giving notice. So
Yes.
then these can happen only after the approval of the chairman only.
Approval,
Chairman approval was not there.
approval is utmost necessary.
Yes,
Without that, my lord, it will be invalid.
yes. Although he has initiated, but then approval was not obtained.
Plus, my lord, whether the notice was served.
Hmm.
Now, whether they have made any aberment in the plain.
No notice, whether notice was served?
No, never.
No notice was served.
No point of time. Even they haven't stated that,
Hmm.
that we have served the notice.
Hmm.
So these are the primary things.
And none of these under 10-4 were also present.
Yes.
So this is your
Now the People's Assembly shall be composed of delegates so and so.
delegate.
These people were not there.
These delegates were not there.
Not there.
Okay, this is the main point.
Yes, yes. My lord, this is the only in fact, this is big, I mean, the papers are voluminous, but then question is this only. Because if Article 29 is not complied, then you cannot pass an ex parte injunction order. My lord, the rule of law is that when you are passing some order, by giving this injunction order, you have given the entire relief. The apex court said you cannot do that because there must be evidence on that. Now, these are the things what we are arguing now.
But thereafter, you have started your own again.
Pardon me? The entire
23.
Yes.
And then your party started.
Yes, our party started. They were elected.
No, how it started?
My lord, we have complete Article 29.
No,
those complaints were there.
It was to be initiated again by the executive.
Yes, it was, my lord.
Who initiated here for?
My lord, the first thing, my lord, here is a case they have come up. First, they want a declaration that the election which held on 14/10/2022, that election is valid election. Now, in order to the court, the power of the court is to see that whether these declaratory relief can be given. First, he will have to prove his own case, whether I have done, whether legally or illegally, that will get a backseat.
Okay.
It's a different case at all. Now, you will have to establish a prima facie case because it's equitable relief you're seeking before the court. Therefore, it is your duty, in terms of section 101, 102 of the Evidence Act, this burden is wholly upon you. It will never shift. You will have to say that declaration which you are asking, you are eligible to get it. And for that, sufficient materials are there in the plaint itself. Because the day one when they file this application, before the court accept the plaint, there is nothing. Because without taking evidence, the ex parte order was given.
Now, can we just come back then? Once, on the basis of which the landed trial court has passed an order, and
Yes.
By which you are aggrieved by.
My lord, I'll take your lordship to that. That will be more easier. My lord, let us see the first order, which is at page 166.
Page
166. Remember
166. Yes.
Start from page 166, order dated 22/12/2023.
Yes.
The petition, lordship has got it, no? The petitioners are
166, yes.
the petitioners are represented by the council. The
166.
Yes, 166. Lordship got it.
Yes, order dated
22/12/2023.
Yes, please.
The instant miscellaneous J application has arisen out of TS number so and so. And the application has been filed by the petitioner's plaintiffs under Order 39, Rule 1 and 1, CPC, read with Section 37(1) of Specific Relief Act, praying for granting temporary injunction by restraining the respondent defendants from using emblem, stamp, and letterpad of People's Party of Arunachal hereinafter so and so. The case of the petitioner's plaintiff is that the plaintiff number 1 is the president of PPA and plaintiff number 2 is the Secretary General as per election held and result declaration dated 14/10/2022. The defendant number 2 was the chairman of Central Working Committee. However, on 24/9/2022, the executive members of PPA convened a meeting and resolution was passed to remove the post of chairman, while 4th amendment on 4/11/2022. Thereafter, the defendant number 2 ceased to be the chairman of Central Working Committee. That by letter dated 14/10/2022, the president of PPA submitted the updated list of office bearers to the Election Commission of India. The Election Commission of India by letter dated 18/9/2023 informed that the details submitted are not in prescribed format of the commission. Therefore, on 27/9/2023, the plaintiff submitted the details as per the prescribed format to the Election Commission of India. The defendant number 2 issued circular dated 4/11/2023 to convene a meeting by stating that the present office bearer's tenure has expired on 22/12/2021 as per the Election Commission notification dated so and so, and published the same in local newspaper on 11/11/2023. On 11/11/2023, the plaintiffs issued a press notice informing party members to refrain from taking part in the meeting as it is unauthorized and illegal. The meeting was held anyway, and defendant number 1, Sri Luigi Boje, was appointed as returning officer and conducted elections on 12/11/2023, and result was declared on the same day. The defendant number 2 was elected as chairman CWC. Defendant number 3 to 22 were elected as state executives. Now that counsel for so-and-so appearing for the petitioner plaintiff submitted that as per 14 of the Constitution of PPA as amended on 4th November 2022, provides for PPA Central Working Committee. As per 14(1), the president of the party shall be the chairman of the PPA CWC. Therefore, there is no separate post of chairman CWC. The defendant number 2 illegally issued circular dated 4/11/2023, and defendant number 1 illegally conducted election and declared result dated 12/11/2023. Therefore, the election result dated 12/11/2023 is illegal and liable to be quashed, and in the interim, the defendants will restrain from terming themselves as the People's Party of Arunachal Pradesh. It is prayed that temporary injunction may be granted ex parte or interim, as the object of granting injunction would be defeated by the delay in service the notice of application to the opposite party's defendants. Peruse the plaint miscellaneous application and the copies of the documents relied on by the plaintiffs. Upon perusal of records and hearing, it is seen that the present case has been filed seeking for decree in favor of the plaintiff for declaration of title in their favor, and a decree declaring the election result dated 12/11/2023 as illegal, and permanent injunction under Section 38 of the Specific Relief Act by prohibiting the defendant from terming themselves as the People's Party of Arunachal Pradesh. I have also gone through the letter dated so-and-so by the Undersecretary Election Commission of India to the President of PPA, wherein it is stated that in regard with the updated list of office bearers furnished by your letter dated so-and-so, it is informed that the details submitted are not in prescribed format. Therefore, it is advised to furnish their organizational election details of the party, along with a complete list of office bearers, members of the committee, etc., elected as such elections in the enclosed format. In the said letter, the Election Commission has not stated that the tenure of the present office bearers expired on so-and-so. I have also gone through the constitution of the PPA. As per Article 12(2), the president shall be elected for a period of 3 years, which implies that the tenure of plaintiff number 1 will be till 14/10/2025, as the election result was declared on 14/10/2022. The election result has not been challenged. Further, Article 14 of the Constitution of PPA as amended on 4th November 2022 provides for PPA Central Working Committee. As per Article 14(1), the president of the party shall be the chairman of the PPA CWC, which implies that plaintiff number 1 is the chairman of the CWC. Further, as per Article 38(1)(a), The President, in consultation with the state executive, shall appoint a returning officer for conducting election of the party, which further implies that it is the plaintiff number one who is empowered to appoint the returning officer. In the instant case, the defendant number one returning officer was appointed by defendant number two. The petitioners plaintiff have a good case to go into the trial and having their claims adjudicated upon. It is party who would suffer greater loss would be said to be having balance of convenience in the favor. If the election result of the defendant rated so-and-so by OP defendant number one is allowed to remain in effect, the hardship or inconvenience caused to the petitioner's plaintiff will be much greater than which is likely to be caused to the opposite party. The state general elections are approaching and the political party is actively functioning. If the defendants 2 to 22 are allowed to function as state executive of PPA parallel to the plaintiff, the comparative mischief hardship of the inconvenience which is likely to be caused to the petitioners by refusing the injunction is greater than which is likely to be caused to the opposite parties if the same is not granted. Therefore, the balance of convenience lies in favor of the petitioner. Further, an irreparable injury must be one of a kind which cannot be adequately compensated by damages. An injury will be regarded as irreparable where there exists no certain pecuniary standards for measuring the damage. In the instant case, if the election result dated 12/11/23 is allowed to remain in force, then it will be difficult to bring back the party status to the present state. The damage caused to the petitioner's plaintiff would be such that it will be possible to the compensated if the case turns out in favor of the plaintiffs. Further, the petitioners plaintiffs have satisfied this court that the object of granting the injunction would be defeated by delay in serving notice to the opposite party, considering the fact that if notice is to be issued and in the meantime, the opposite parties might end up making major party decisions and alter the position of the party. Accordingly, the election result of the defendants number so-and-so declared by defendant number one, Sri Louis K. Boje is hereby stayed until further orders. Further, the defendants number so-and-so are restrained from functioning as state executives PPA and further directed to refrain from using the emblems, stamp and letter pad of the People's Party. Now, your lordship kindly see, they have considered the case of the defendant, not the case of the plaintiff.
Yeah, yes, that is there. But then have you challenged their election?
My lord, that it is challenged. It is also there. No? Is a pending in the court below.
It is pending.
Yes. So now here, so far this case is concerned, now the primary duty of the learned judge was.
This challenge was done prior to or after they had challenged? After. Okay.
But that's a different question, my lord. I am not much on that. The first question so far this case is concerned, when plaintiff is asking for the declaration of his result, that is election result dated 14/10/2022, that is a valid election. Where is the substance in regard to that? Where is the, my lord, the statement of fact that by maintaining the core question of Article 29, by complying that you have conducted the election, you have amended the Constitution. Where are those things? It has not been replied by the learned judge. Learned judge has assumed whatever they have stated is a gospel truth. Now, my lord, all right, at the time of giving ex parte order, since they have suppressed the fact.
In your challenge petition, probably that will be reflected.
That's
if you have challenged. Now you have challenged.
My lord, that's a, my lord, so far I am on this case. Then so far this case is concerned, is the plaintiff will have to stand on his own leg. Now, where are the materials of satisfaction of the learned civil judge that he has come to a finding the election dated 14/10/2022 was a valid election? Where is the finding? Did he go to any extent to that? Because when you say there is a constitutional amendment.
No, that was not under challenge.
No. My question, my lord, that's the reason you lost
so far, that was not under challenge at the time of passing this order, probably.
It is not under challenge, but you will have to prove it. Otherwise, what will happen? I will say something.
That was not under challenge.
My lord, that's so far injunction is concerned, it is not required to be challenged. You are saying this is a valid election, I want an ex parte injunction order. Then the law is plaintiff will have to prove his case first. Prima facie case he'll have to establish. He'll have to say that this is a valid election. And in terms of Article 29, People's Assembly was there. People Assembly, after the taking the consent of the People's Assembly, Constitution was amended. Now, where are those things? Where are the averments in the plaint? Nothing. The learned judge can say at best that at the time of ex parte, passing ex parte order, since the materials were not there in the plaint, we assumed whatever he has stated, that is the correct position. All right, I can understand. But we filed an application under Order 39, Rule 4, my lord, explaining all these things. Even then, my lord, they did not go into all that. Rather, the finding is they may have violated those constitutional provisions.
Now the Land Trial Court, while observing that their tenure still or their tenure is up to 25, assuming that their election was a valid election.
No, my lord, no.
Because it was not under challenge. You did not challenge that.
My lord, I'm sorry. I am so far injunction.
No. Their assumption.
There it is an assumption. But can the court...
It is okay. It is fine, of course. You are right when you say that they did not made an observation that about the compliance of the 29, etc., etc. But then at that moment, when they filed, the petitioner, probably the Learned Trial Court had an assumption that their election was valid. Because it was not yet challenged by you.
With due respect, should the court go on assumption? When a person has come...
It was not under challenge. What I'm saying is, it was not under challenge. You have not challenged it.
It is not necessary at all. My lord, I am on the law of injunction.
At the time of establishing that, they are, of course, they need to, of course, establish their right.
My lord, so far injunction matter is concerned. My lord, when somebody is claiming that these, your lordship kindly see the... My lord, your lordship kindly see page 90. What is their prayer? Plaint. I'm taking your lordship to the plaint.
90.
90. First prayer is declaring the plaintiff's right over the title of People's Party of Arunachal. Then declaring that the impugned election result PPA dated so and so as illegal. Further declaring that the defendant. Now these are so far my case. Now first is declaring the plaintiff's right over the title of People's Party of Arunachal.
For declaring the plaintiff's right over the title of People's...
The title word is not correct. Actually, there should have been that the election held on 14/10/2022 is a valid, because ultimately they have said that. Now,
if this is prayer, then they need to establish even
my lord, in
they need to establish
injunction petition, you will have to establish a prima facie. Prima facie case means what? Well, when you are asking for something, this is your bounden duty. You are to, my lord, justify your case. And court will have to ask for.
They need to establish their...
Well, in a routine manner, my lord, what she has said, that the learned judge, he or she...
In order to declare...
The learned judge has given all this routine manner, irreparable laws, prima facie. What is where is the prima facie case?
Yes, and prayer to declare, then it would require...
Either she is oblivious of the legal position, or she has done in a routine manner. Because this much I can say about the learned judge. Even the appellate forum, and ultimately, my lord, your lordship kindly see, these are so much a ridiculous thing. We feel shy to say all this thing before the court. My lord, the order which is challenged by filing order 39, the order passed on page 57, your lordship. 57. The finding, I will take your lordship to the finding only. We filed an application to vacate, and what she has said. My lord, Page 62, your lordship, kindly see. In a so much casual fashion, the finding is given. Possibly you never read section 30 of CPC. Page 62, my lord.
62.
Para 22. I'll read the whole order, but then I'll take to your lordship to that finding.
62, this is,
Page 62 of the paper book.
okay, 62 is, this is order.
That's we filed an application for vacating the order, ex parte order. And she has passed the order in the finding at page 62, para 22.
Is it the impugn order?
This is the, subsequently, we filed an application to vacate the ex
Okay,
parte
for
order.
vacation, okay.
And the, my lord, her finding at paragraph 22.
Yes.
Therefore, in my view, the opposite party's plaintiff may not have followed the procedure provided under the Constitution for amendment of the Constitution. However, the contention of the petitioner cannot constitute evidence that the plaintiff had made false statement. What is this? You are agreeable that they may not have complied the provisions of the Constitution.
In my view.
This is the backbone of the case. Once, my lord, the mandatory provision has been skipped, that amounts to tantamount to mislead the court. No, these are the things, my lord, they never gone through, my lord. Now, your lordship, if your lordship like to see the petition we filed for vacating the ex parte order, which your lordship will find at page 170. Then once again, I will take your lordship to that order.
One.
170, my lord. We filed an application to vacate the ex parte order. Well, while passing the ex parte order, the learned judge did not have the materials, but while we filed our application, we have explained everything.
Yes, 17.
170, which start from page 178.
Okay. This is application. This is
Application by the defendant under order 39 rule 4. Your lordship may come to page 178.
This is application filed by
the defendant. Under order 13 rule, order 39 rule 4.
Okay. Order, page 170.
178.
Yes.
I'll read from paragraph 3. That the applicant number 1 is the founder president is Kamen Ringo, 2007 of the People's Party of Arunachal, hereinafter referred to as PPA, who was elected as the chairman of the Central Working Committee for the session on 23/1/2018 for the session 2018 to 2021. The respondent number 1 and 2 were elected as the President and Secretary General of the PPA party. After expiry of 3 years tenure of office, the next election was supposed to be held in the year 2021. However, no elections were held, and the members have continued to hold their elected post beyond the tenure of 3 years. That this application is preferred by the applicants mentioned above under Order 39 Rule 4 of the CPC to set aside the order dated 22/12/2023 passed by this Honorable Court granting an order of injunction in favor of the plaintiffs in this case number so-and-so, title suit number so-and-so, by which the election result dated so-and-so conducted by an applicant herein and defendant number 1 to 22 in title suit number so-and-so was stayed. And the applicants were free from functioning as state executives of the People's Party of Arunachal and even refrained from using the emblem stamp. Lord, the interim order was passed in such a manner as if it's the final relief. Even I'm not in a position to use my pad also. The applicant most humbly beg to state that the respondents herein, who are the plaintiffs in title suit number so-and-so, have misguided this Honorable Court and have maliciously retrieved the ex parte interim injunction against the above mentioned applicants. At the very outset, the applicants beg to state that the respondents have misguided this Honorable Court by placing reliance on a non-existent Fourth Amendment of the Constitution of PPA. The respondents were the plaintiff in title suit number so-and-so and miscase number so-and-so have made submission in their claims and that the applicant number 1 was the chairman of the Central Working Committee. However, on 24/9/2022, the executive members of the PPA convened a meeting and a resolution was passed to remove the post of chairman by Fourth Amendment on 4/11/2022, and hence the applicant number 1 ceased to be the chairman of the Central Working Committee. It is pertinent to mention herein that the submission of the respondent as well as their annexures are silent with regard to the conduct of People's Assembly, which is the only way through which any amendment of the Constitution of the PPA can be done. Article 29 lays down the provision with regard to amendment and states, the party constitution shall be amended only by the People's Assembly. The notice or proposal for amending the Constitution shall be given 1 month before the said Assembly. Hence, it is clear that no amendment of the Constitution can take place without holding People's Assembly. The alleged fourth constitutional amendment of PPA can only be treated as a draft proposal at the most, as compliance to Article 39 is mandatory to amend any article of the Constitution of the entire Constitution itself, which in the case of the respondent did not take place, as no notice was issued 1 month prior to proposing the amendment of the Constitution, nor was any People's Assembly conducted to pass the amendment. Then the Constitution we have annexed. Then the para 7, my lord, that the applicants beg to state that according to the Fourth Amendment of the Constitution of PPA, submitted by the respondent in their plaints in title suit number so-and-so and miscase number so-and-so, the drafting committee includes 4 members, including the respondent number 2, Sri Kaling Jerang, that all other 3 members of the drafting committee, Sri Rigam Santana, Sri Marli Kamki, and Sri Tai Tadap, have raised objection with regard to the Fourth Amendment of the PPA Constitution and have submitted in their letters to applicant number 1 that no People's Assembly has been conducted till date for amending the Constitution and no such resolution was passed to remove the post of chairman of CWC as claimed by the respondent herein, and the Fourth Amendment is illegal and cannot be upheld in law. Page 293. Your Lordship may see the annexure, which your Lordship will find at page 293.
293.
Page 293, I think, in the next volume. ये हमारा है ना? मेरा कहाँ है? मेरा कहाँ? No, this.
I think we may have to continue.
Oh, yes.
I don't know how much Marciner will take because last time also he took almost 2 hours.
Possibly I have just started.
That's why I'm afraid.
You
No,
just started.
Only thing, my lord, unless I take your lordship to all these things, your lordship will not get the thing.
Right. That is true. That is true.
I thought I will take half an hour only, but
I think it's not possible for you also.
I will not take much.
My lord, the point is so short.
So, but then still.
That's why, my lord.
Unless I say all these things, it's not be very clear.
It is correct. Point is very small. No, my lord, we have not argued before an appellate court. My lord. This is a revision court, my lord. All those things, my lord, facts and my lord, some things are not necessary at all. Also. Definitely some legal points, my lord, senior raised. Those are very points.
Yeah, only thing.
What I'm requesting is we can cut short, my lord. It will save time of this code and us also.
Even I am much eager to go early.
That's
So that I can attend tomorrow's court there.
Find out.
It can be cut short, man. I'll take maximum of half an hour or 45 minutes.
And it's for me, I will get a sigh of relief if I can finish it because
Right.
once I again start my lord, I have to read for 4 or 5 hours.
Right.
So therefore is a lot of problematic thing.
Okay.
Because
We'll continue.
already, my lord, last time also sufficient time, about 2 hours was taken, my lord. So
Right.
I think
And I think
Probably other
it can
method.
be just a refresh on
Other method, we may not be able to take up the other method. Is there any other method
I think, but
in the arsenal?
we are afraid for them. Others also, my lord. For personal service notice, my lord.
Item
28.
28. This is for what?
I is for my lord, watching of service notice, my lord, upon respondent number 5, my lord. Because my lord, respondent number 5 has changed their address, my lord.
Okay.
Posted to another place. Therefore, IA is file for watching service of notice on the new address, my lord.
Okay.
So, my lord,
Okay, hard, Mr.
us will after
Afternoon.
oblige.
We'll take 1-2 minutes. Okay. Hard, Mr. Hey, Dari. The land counsel for the applicants. Stop. This is an application. Praying for replacement of the address of private respondent number 5.
Yes. My lord will find address in page number 5, my lord, I've given.
Respondent number 5.
This everything will be mixed.
Who is respondent number 5?
5 is my lord.
Yes, okay.
Tam Tapa, my lord.
Okay. Is Sri Tan Tapa, care of Principal Government Higher Secondary School, Sagali, District Papumpare, Arunachal Pradesh.
Yes, ma'am.
Okay.
I may allow to take a step on.
And to take steps in the above new address. The prayer is allowed. The petitioner shall take steps upon the respondent number 5 in his new address.
Yes.
Within a
3
days from today.
I can dispose of my.
The IA with above the IA stands disposal in the main.
Main case, my lord, the private respondent number 4 is yet to file their affidavit in opposition.
Okay. In the main, Mr. Ketari. So in view of the order passed in the IA today, that is so. The petitioner shall take steps upon the respondent number 5 in his new address within 3 days from today by a registered post with ID. Okay, stop. The respondent number 4 not yet. Okay, as per,
yet to file
Okay.
affidavit of opposition.
as,
Government has filed here.
the office notes dated 24/5/24 reflect that the affidavit. No, sir. Just a minute. The respondent number 4 is yet to file affidavit. Okay. List this matter after
3 weeks.
3 weeks. Okay.
All right.
Oh, 35 is hearing. We can't. Okay, keep that. Okay. We'll resume it too. Huh?
My lord,
Yes.
item number 35,
35. We'll,
after 3 weeks, your lord,
okay. As prayed for by Lanaka. You are for a petitioner.
for the appellant,
As prayed for by the Lanaka Council for Appellant, Mr.
T. Sering, your lordship,
List this matter after
3 weeks.
3 weeks.
Oblige.
Unlisted matter, mentioned matter, my lord. Just may kindly take up after my lord, lunch break.
What?
Unlisted matter, my lord.
Okay, this is regarding.
Yes, matter, item number 36. 36, my lord.
Oh,
Unlisted.
36. This is what? This is
AB,
about
AB. Inceptory bail application.
BA.
AB.
When do you want?
My lord, no, my lord. I just want it to be heard today, my lord.
Today?
Yes, ma'am.
This was a mentioned matter.
Mentioned matter.
Mentioned
Just
matter,
allowed by my lord.
What is the offense involved?
My lord. My lord, 376, 354 and 506 IPC.
Pre-arrest bail.
Pre-arrest bail. My lord, the content of the
Offense is
376, my lord.
376.
376, 354, 506 IPC. My lord. Complainant is, my lord.
Just a minute.
Complainant, she is a, my lord, teacher by profession. And his accused is a professional. There at Bumdela College. We have been in a relationship since very long period of time. This FIR, contents of FIR, disclosed that, my lord, it was completely out of consensual, my lord.
So, notice can be issued. To call for the
Case diary.
case diary. Okay.
Till then, my lord,
Hard, Mr.
maybe
Hard, Mr.
Jiriba.
Lanaka Council for the petitioner. I've also heard Mr. Siri, Lanaka PP for the state of AP, start. This is an application under section 482 of the 482.
My lord, as well as I have posted book 438. 438 service also.
This was dated
On FIR relates to 3rd of this month, my lord.
3rd of June.
So then it is 482.
482, my lord, instead of 438.
Okay. 482 of Bharatiya Nagarik Suraksha Sanhita 2023. Praying for grant of pre-arrest bail, apprehending his arrest in connection with the Rupa PS case number 12/2024 under section.
There is
No.
one small difficulty in this.
Difficulties, here again you have said.
One of difficulty is SP of 376, it should be section 69 of.
Yes, because you say
Because
you have filed under 482, and then here again you have mentioned 376.
Malum.
No, that
Malum,
is,
It's contents of FIR, Malum. Those defects, those sections, 376, 352, all that.
Okay, the police has registered
Yes.
under the old act.
that is on the lacuna,
It's correct.
that is lacuna on the part of the,
Application filed under this 430A, read it 482 is correct. Because if you don't file under 482 of the BMS, then he has to correct the cost title.
Right, no.
That is one aspect. Therefore, instead of correcting the cost title, now he is right. One. And number two, the cost of action has risen after the implementation of the BMS,
Yes.
new criminal law. So therefore, observation is made, these sections, 376, 50, 354,
A.
and 5A, 506 has been invoked in this case. These are all non-binding. So in that even, the officer in charge may not be trained.
That is right.
Invoke this sections. So might not be indicated that particular thing, it should be converted to the new provision of BLS.
that is, my lord, this is 482 jurisdiction, my lord. Such direction may not be required. That is on the prerogative of the investigating officer. There has been a lacuna on the part of the IO, the concerned police department. It is on their part to, yes, my lord, OC. That is on their part to rectify this, my lord. Direction is not required.
Correction is?
Direction.
Only indication. Indication. That is one thing. Then that actually like 376 now converted to 69 BLS. And I am assisting the PP, earlier it was 301. Now it is 102.
Okay, you're for the complainant.
Yes.
But it appears that there was no forceful.
Yes.
No, the question of forceful does not.
Now, earlier 317.
Yes, does not appear.
Earlier 317 was
Yes.
tried.
It is the maker of the promise to fulfill the promise that he has made. Now, here is a case that when that subsequent development took place, I conceived, I was taken to case court, tried to have a forceful MPP form, medical termination of signation. That was unfair, and then again they went there. So therefore, this appears to be heinous. Now, under this 69 of the BLS, it is very dangerous. And there is one judgment, that's
My lord,
my lord,
a notice has to go to the informant first, and then to set it straight, my lord.
You have impleted the.
No, Malum.
No. Then you have to implead. No.
Only in Malum.
The victim needs to be.
I suppose, my lord, in
Is it compulsory?
No, my lord. In
376 is not compulsory, only in POXO.
On POXO and 376 AB, AD,
Right.
all those cases.
Right.
In this, not mandatory. And my lord, the complainant or the informant can only assist the BP, my lord. They cannot make an independent submission before this honorable court.
Well, subject to the deviation of argument by the BP or the law firm.
Yes.
Okay.
More cycle years to correct it. Below that, local law judgment and subsequent that our notice. I think notification number 9.
That's necessary. Under section 482 of the Bharatiya Sangra Nagarika Suraksha Samhita 2023. Within bracket, Grade in section 438 of Criminal Procedure Code 1973. Now repeat. Bracket close. Okay. In the earlier, okay.
The incident, unfortunately, is covered by Monday equal power judgment. And my brothers would sum up with Deepak Gulati and the national judgment Ravindra. But what would be of no help to me?
Okay, we'll see the case there then.
Yeah.
Okay, call for
What pray, Lord,
the
till them at
case.
least I maybe will
Case
protect
diary.
it.
Scan copy of the case diary. Issue notice. Since Mr. Srilankan PP accepted notice on behalf of the state. No fresh, no formal notice need be issued. Start. Okay. For case diary, scan copy of the case diary. Issue notice are returnable by.
How many days? 10 days.
Returnable by.
1 week, 17 more make one.
This is which PS case?
Rupa
Rupa.
PS, Rupa PS.
How long it will take? 10 days.
If I have to obtain by a scan copy, my lord, I can produce it within 2 or 3 days also if required.
17 then.
Otherwise,
Okay.
1 week
Then,
time.
then when do we fix?
17 Malot. 18 Malot.
18 is okay.
Yes.
18.
18 Malot.
Okay. Okay.
Thursday Malot.
Thursday.
Thursday or
Okay.
Friday.
Okay. 18, no?
It will be too early for you. Sure. Okay, Manoj, whatever convenient, you know, because no entry is there. So
Malot,
they are also-
till then Malot, at least.
Till then, it has to be protected.
No, this is really, if Manoj reads section 59 BIS.
Just a minute. Just a minute. Let us.
Malot, this FIR itself, Malot, discloses they were in the relationship. Malot. Completely out of their consensual. Malot.
Where can you get the case?
After hearing of.
3 days.
Okay. Now there is some difficulties. Pregnancy and the termination also forceful.
Malot. Malot, in this case, Malot, complainant she is Malot 32 years old. Malot. And by profession she is PGT, Malot. Teacher. And accused is a Malot profession. Being arrested, Malot, I will be in humiliation mode. There would be a disgrace mode. So at least Malot till 18 Malot, I may be protected.
But on morality also, the professor is not supposed to do this kind of thing. Normally, I don't have an interest in this kind of bail application.
Well matured and Malot, educated ladies is now.
Have you given? You have an extra copy? I'm going to have the copy of jail application. Why not we read from there are 7 of the file?
Oh, so it's very long.
Yes, there are 7 and 8. These are important. It says, Malor, after hearing of my pregnancy, Mr. So and so possibly taken me to case 2 for termination of pregnancy, though I reluctant for termination of pregnancy. Under his pressure, I proceeded to page 2 on 6/6/2024 along with him and we stayed at hotel Northwest. Next day, I underwent medical checkup at healthcare. So doctor advised me to avoid the termination of pregnancy. That is 5 weeks, therefore, that has developed, the fetus has developed human form. After that only, started treatment.
There's some trouble still. Then you produce on that, let us see our statement, etc. Okay. Section 18. Okay.
Till then, Malon,
The interim, anticipated, the interim prayer shall be considered on that side.
Malon, because Malon,
There is some
I will
serious allegation it appears. I
till
thought
only
that
for
there
Malon,
there is a counsel.
18 only, Malon. I humbly pray, Malon. Till on 18, Malon. Till the city arrive. If Malon, if city, Malon, there is any matters against you, Malon, it can be cancelled, Malon. But till only 18.
We'll consider on that. Let us see, let us see.
May I, your lordship, with one request. Item number 12, your lordship. Unfortunately, I was occupied in court to your lordship. That's why I could not appear. Item number 12, your lordship. 12. And I have already informed.
What do you want? What do you want?
The matter may be listed after. It's a solution matter, your honor, your lordship. It's a solution matter, your lordship. And the similar matter is already pending before Apex Court. So if the matter may be listed after the order is passed from the Apex Court, then.
What was the order passed here?
Item number 12.
Well, after 4 weeks.
4 weeks.
But we are marked as absent.
Okay.
We are marked as absent. Let the record
their
show.
present may be recorded. You are for?
Petitioner.
And you are for?
Both.
Okay.
On behalf of Suku Koyang.
It is prayed for by the Land Council for the petitioner, no?
Yes.
Release this matter after 4 weeks.
After the matter is adjudicated at Apex Court, your lordship, because.
Okay, when do you want?
After the matter is.
Okay.
Adjudicated before the Apex.
Okay, then, item 12, Land Council for the petitioner submits that the
Similar matters before the Apex Court
the
pending.
similar matter is pending before the Apex Court.
Yes, your lordship.
Similar matter is pending before the Apex Court in.
Yes.
You have to. Yes, number. Appeal.
Your lordship.
Similar matter is pending before the Apex Court.
Yes, Supreme Court, yes.
Okay. Hence pray for listing this matter after the disposal of the same.
Yes, your lordship.
Matter, okay.
Yes.
Okay, list this matter. You mentioned then. List this matter. When, because we do not know when it will be disposed of. After the said SLP, you have to give number is disposed of. SLP.
Okay.
You give the number then.
Yes, okay.
Okay.
Okay. Deeply obliged, your lordship.
Your lordship may look at page 181.
Page
181.
Yes.
We read up to paragraph 7.
Yes.
It's 93 shall operative, na? Well, I'll read once again. Paragraph 7. The applicants beg to state that according to the fourth amendment of the Constitution of PPA, submitted by the respondent in their plaints entitled suit number so and so, miss case number so and so, the drafting committee includes 4 members, including the respondent number 2, Sri Kaling Jarang, that all other 3 members of the drafting committee, Sri Rigam Santana, Sri Marli Kamki, and Sri Tai Tadap, have raised objection with regard to the fourth amendment of the PPA Constitution and have submitted in their letters to applicant number 1 that no People's Assembly has been conducted till date for amending the Constitution, and no such resolution was passed to remove the post of chairman of CWC as claimed by the respondent herein, and the fourth amendment is illegal and cannot be upheld in law. Copy of the letter dated 24/10/2023. Now, your lordship may see that letter at page 293. Page 293, your lordship will find this is the letter to the chairman CWC by 4 of the members, my lord. I'll read, my lord, the letter dated 24/10/2023 to the chairman, People's Party of Arunachal. Clarification to PPA President letter number so and so dated 20/10/2023. Which your lordship may see the next page, that is the type page, this is a clear one, 293A. With reference to cited above subject, we the undersigned would like to clarify the reply made by the President PPA in the following few lines for your kind clarification. That said, it is a misleading information that Article 13 has amended and the post of CWC chairman has removed, which stated in his letter is purely a malafide intention to defame the great reputation of PPA, which founded by our great former leaders of the party. The letter replied by the president is deviated from the facts of the matter and tried to escape from realities. The fact is that on 24 September 2022 was an executive meeting to take a resolution to propose for amendment of the Article 13 by convening a People's Assembly to seek consensus to adopt the amendment by the People's Assembly. Unfortunately, the Article 29 amendment procedure has precisely written that the party constitution shall be amended only by the People's Assembly. The notice or proposal for amending the constitution shall be given 1 month before the said assembly, and invoking said Article 29 never been conducted till today. It is yet to convene the People's Assembly for party organization election, and in due course of time, Article 13 or any other article, clause, subclause of the party's constitution. Then your lordship may skip to page number 64A.
This was only after, I think, 2000.
Some of the members, my lord, making the allegation.
So draft was done in the 2022 only.
Yes.
So this was long after more than a year, probably.
Yes, that means they want to say that so-called election as well as the amendment, what was not in right direction, as not in conformity with the constitutional provisions. And some of them are the members of the draft committee. No? They are the members, some of them are the members of the draft committee. So they are not satisfied with this sort of amendment, because amendment, in order to amendment, my lord, only it can be done by the People's Assembly. No such People's Assembly ever took place, and no notice was ever given. So that sort of complaint came from the draft committee also. So that's why, my lord.
After 1 year.
Yeah.
Of the drafting, after they have already signed.
Right. And then page 64A, the last part. Whereas question of amendment to Article 13 or removal of CWC chairman does not arise, hence your kind authority is prayed not to confuse or feel ambiguity about the party constitution. The party's constitution is vividly expressed the power and functions of the members of People's Assembly and others therein.
This is para 8.
This is para 8, my lord, the annexure I'm reading.
Oh, annexure.
Yes, yes.
Page,
Which your lordship will find is para page 293, small a. This is annexures.
small a. This we have read.
Yes, then the next page. That also 293B, your lordship has read. Then 294, then 64A, this page. 64A, na? 294. 294A, my lord.
94A.
Yes.
Yes, yes. What is this?
Whereas question of amendment to Article 13 or removal of
This is also
CWC.
part of this annexure.
Yes, yes.
Okay.
This is the typed copy, my lord.
Okay.
Whereas question of amendment to Article 13 or removal of CWC chairman does not arise, hence your kind authority is prayed not to confuse or feel ambiguity about the party constitution. The party's constitution is vividly expressed the power and functions of the members of People's Assembly and others therein. Therefore, your august office is prayed to convene the People's Assembly as soon as possible by virtue of expiry of the PPA tenure on 22nd December 2021 and is a matter of serious urgent. Yours sincerely, Irigam Santana, Vice President, Taitada President, Marley, General Secretary, Tawataga Treasurer. Now then, your lordship, kindly see paragraph 8 of the page 81, paragraph 8.
Yes.
181 minute. That the applicants beg to state that the applicant number 1 is still the acting and existing chairman of the Central Working Committee, as the 4th Amendment of the Constitution of PPA is untenable in the eyes of law. That being the case, the applicant number 1 being the chairman of CWC is hence empowered to take actions for the interest of the party. As the chairman, CWC is a approving authority for all important decision of the party. Now, under Article 13(4), my lord, your lordship has already read. I am not reading once again that. Your lordship may come to paragraph 9, my lord, at page 183. Paragraph 9.
Yes.
That the applicant back to state that on 13 September 2022, a letter was received from Undersecretary Election Commission of India stating that the term of office bearers of PPA party has expired on 22/12/2021 and that no update with regard to the organizational elections of PPA party has been received at the commission. The PPA party was further requested to furnish information regarding the organizational elections of the party along with a complete list of current office bearers, members of the committees, etc. immediately on the email already given. A copy of the letter dated 13/9. Now that letter your lordship will find at page 280.
Page
280.
280.
My lord.
0.
The letter from Election Commission of India dated 13 September 2022.
Yes.
To the President, People's Party. Subject, People's Party of Arunachal, recognized state party in the state of Arunachal Pradesh. Change of address and to conduct the organizational election. I am directed to refer to your email dated so and so on the subject cited and to state that the term of office bearers of your party has expired on 22/12/2021.
So
Further,
this refer to the earlier tenure.
Yes, yes.
of the
That
PWC.
Election Commission of India, they have informed them, they expired on such and such date. You did not update the election. So just after these letters, my lord, all these election processes started.
Okay, so this
Further,
letter,
my lord,
just a minute. This was 13 September 22.
yes, yes.
But then by that time, the election, it was
This 14-10, 14-10, 2022 election.
Yes, yes. So this is
Started
13
just after
13
that.
This is 13-9.
13-9.
Okay.
And your lordship will find very interestingly, after this letter, this president and secretary started up and doing to conduct the election by illegal means. And therefore the chairman sent them a letter, don't do it, whatever you want to do it legally. Now I'll take your lordship to that next page it is. Now I am directed to refer to your email dated so-and-so on the subject cited and to state that the term of office bearers of your party has expired on 22/12/2021. Further, no update in regard with the organizational election of your party have been received at the commission. Therefore, in view of above, it is requested to furnish information regarding the organizational election of the party, along with a complete list of current office bearers, members of the committee, etc., elected at such election in the enclosed format. The same may also be communicated and the email given immediately. Further, in regard to change of address, these are your lordship may skip. Then, my lord, your lordship kindly come to page 183, paragraph 10.
Paragraph 10.
Paragraph 10.
Yes.
That it is the contention of the plaintiff in title suit number so-and-so that after the above mentioned letter was received by the office of the president of PPA party, an election was held on 14/10/2022 and notice with regard to the election was published in the newspaper on 2/10/2022. Thereafter, the respondent number 1 and 2 were elected as the president and secretary general of PPA party, the results of which were accordingly submitted to the Election Commission of India. However, the said election dated 14/10/2022 never happened, and the newspaper publication and notices were a mere showcase for establishing the conduct of an actual election which did not happen at all, as the conduct of People's Assembly is a mandatory to conduct any party election. The applicants most humbly beg to state that all the members, including the respondent herein, Sri Kafa Bengia and Sri Kaling Jerang, were appointed to their post by the respondents themselves, merely for the sake of formality, so that a list of office bearers can be sent to the Election Commission of India and to comply with the letter dated 13/9/2022 received therefrom. The applicant number 1, on seeing that the notice for election has been published in the newspaper without following due procedure under the Constitution of PP, wrote a letter to respondent number 1 on 5/10/2022, appealing him to conduct the election according to the provisions of the PPA Constitution by conducting People's Assembly and by giving 1 month prior notice before such election. Letter dated 5/10/2022 is enclosed. Now that letter your lordship will find at page 281, my lord. It is addressed to the president by the chairman. So the president's.
The president was still, at that time also, he was a president.
Yeah, he was president. I have seen the notice issued by the party regarding election of party president and chairman of Central Working Committee and either party constitutional post in the party at present. I am not only the founder president 2007 of president PPA party, but also holding the post of chairman CWC PPA under the same party. I deeply felt that some lacuna under party constitution, Article 13, could be thoroughly discussed and if necessary, this lacuna could be do away with certain amendment in the party constitution. In order to do this, we must see Article 29, that in party constitution shall be amended only by the People's Assembly. The notice or proposal for amending the constitution shall be given 1 month before the said assembly session. I therefore request the party president to defer the holding of party general election, which scheduled on 14/10/2022 for the greater interest of PPA party and People's Arunachal Pradesh. This is by Chairman Kamin Ringo, Central Workings Committee, PPA. Then page 184, paragraph 12. That even after receiving the letter dated 5/10/2022 from the chairman of PPA, the respondent number 1, without conducting People's Assembly and following the procedure under the PPA Constitution, manufactured their own documents showing that party organizational elections were held on 14/10/2022, made a list of office bearers and sent it to the Election Commission of India. However, on 18/9/2023, a letter was received from the Office of the Election Commission of India stating that the list of office bearers are not in prescribed format. A letter dated 18/9/2023. This letter, Your Lordship will find at page 134. Page 134. Yes, me. 134. 134. Eight, nine, yes. Yeah, no? Yeah. This is to the President, People's Party of Arunachal. I am directed to refer to the Commission's letter dated 36/2010 on the subject cited above, wherein you were advised to suggest a symbol. This is the paper or what? Well, just 1 minute, please. We are referring which one?
This is regarding symbol, I think. 133 or 34.
This is regarding symbol, but
34 is regarding recognition.
134, correct? 340 है 340. Just a minute. Melody, Your Lordship may see page 340. Yes. Contents क्या है?
is also in office here.
Mhm. 134. Correct. 135. Lord, I'm sorry, your lordship may look at
No problem.
page 135.
135.
135. To the President, People's Party of Arunachal, I am directed to refer to your letter dated so and so on the subject cited, and to state that the request for change of party's address has been acceded to by the competent authority and accordingly taken on Commission's record. Further, in regard with the updated list of office bearers furnished by your letter dated 14/10/2022, it is informed that the details submitted are not in prescribed format. Therefore, it is advised to furnish the organizational elections details of the party, along with a complete list of office bearers, members of the committees, etc., elected at such election in the enclosed format. Further, in regard to change restoration of symbol made known as reserved symbol of the party, your kind attention is invited to Commission's letter dated so and so. Okay. 185. Yeah. That one. Yes. My lord, your lordship, now see paragraph 14, 14, paragraph 13, my lord. Of page 185.
Yes.
Then, my lord, 185, para 13.
Yes.
The applicants most humbly begs to state that the list of office bearers and the documents submitted by the respondent could not have been in the prescribed format because of all documents were manufactured by themselves without conducting proper election. The applicant number 1 also addressed a letter to respondent number 1 on 5/10/2023 in pursuance of the letter of the Election Commission of India dated 18/9/2023, intimating the then President to conduct proper election for the new executive members in accordance with the provision of the Constitution of PPA. However, these requests were completely ignored by the respondent number 1. That letter, your lordship, will find at page 341. The clear paper, your lordship, 341.
Yes.
To the President's People's Party of Arunachal, with reference to Election Commission of India letter number so and so dated 18 September 2023, which stated that the due date of party organization election has expired on 22nd December 2021 and sought for new elected office bearers while rejecting the alleged election conducted by R.O. Sri Taba Tagar within short period of 10 days of time is improper election format. During this period, I have written a letter to you by suggesting that your alleged party election is improper, shortage of time, that also without conducting People's Assembly. As per Article 10 of the party's constitution, the of the party for the whole state shall be the People's Assembly. The conference of the People's Assembly shall be convened by the executive ordinary once in every 3 years. An extraordinary People's Assembly shall be called by the state executive when it is demanded by 2/3 members of state executive. The date and venue of the conference of the People's Assembly or of the extraordinary People's Assembly shall be decided by the state executive at a meeting specially called for the purpose. The People's Assembly shall be composed of delegates elected by the so and so chairperson and shall have the right to participate as full delegates in the People's Assembly, whether regular or extraordinary. Then next at page 186, paragraph 14. That the applicants were to state that in response to the letter dated 5/10/2023, the applicant number 1 was issued with a letter from respondent number 1 stating that the post of chairman has been removed by the 4th Amendment. However, the applicant received letters of clarification from the General Secretary and Treasurer of the PPA party, Sri Marli Kamki and Taba Tagar, respectively, stating that no such amendment for removing the post of chairman was passed. This letter, Your Lordship, will find at page 348. 348, mein log. G48, and the typed copy Your Lordship will find at page 348A. Yes. To the Chairman, Central Working Committee, People's Party of Arunachal Pradesh, it has come to my knowledge that one new APPA constitution book under the title Judicial Amendment is currently under circulation. The contents of same entails the drastic changes to the original PPA constitution. I had previously joined the party on 14th October 2023. I was provided with the party constitution 3rd Amendment along with my file. During the course of time, in numerous formal and informal sittings of the party, 1 2 members had initiated discussion for amendment of the party constitution, and on such occasion, a 4-member committee of which the undersigned was also one of the members, was also formed to study the original party constitution and recommended necessary changes. This committee had a sitting at Itanagar only once, whereby it was hastily decided to add or delete any articles of provisions. After repeated requests from the President and Secretary General, an incomplete draft in book form was submitted to the party president at his residence by the undersigned in presence of one of the secretaries, with a clear-cut intimation that the said draft was incomplete and the same was not to be circulated before carrying out all the necessary process and formalities. There was also informed that the draft was not unanimously approved by the 4 members committee, and as such, the draft did not contain signature of any of the committee members. Further, the dates of state executives and People's Assembly was erroneously mentioned in the said draft in anticipation for the same to be conducted on the invented dates.
This was written by?
This is written by, Your Lordship will find that at page
General Secretary and Treasurer.
General Secretary, People's Party of Arunachal Pradesh, the Marley Kamki. Now, Your Lordship, see at page 349A.
This is also after election.
After these are all after election, my lord.
Because
Because
after 1 year of the election.
my lord, everything happened surreptitiously. So therefore, when they found all these things, they brought in the book.
But then it was published in the paper.
This election was a paper election, nothing else. Therefore, there is no materials either in the plaint or they could have adduced evidence. They did not do it.
Immediately after the purported election being conducted was published in the paper.
Yes.
So immediately paper, these old complaints were not there. But only when the election notification came, isn't it?
My lord, what happened? Now, this was a fake election,
Yes.
invalid election. So therefore, the main election which took place in 2023, now it was done validly and they were appointed chairman, president and all the 23 members. Now, when they found that they are going to form the body, they found that their position will be in a hopeless position. They filed a suit. Now, by filing a suit, without making the averments in the plain that we are required to go by the Article 29, Article 13, Article 10, Your Lordship will nowhere find in the plain that all these things, all these have been heard. So those are the things they have suppressed, and when the election was conducted, full-fledged election was there, they found their position is going to be, all these peoples are going to be out. They did all these things.
Okay.
Now, the page 349, Your Lordship kindly see, 349A. The new PPA.
This is another letter.
The continuous continuity, my lord.
Okay.
The typed copy.
Okay.
The new amendment makes changes to the Article 13, thereby omitting the position of chairman CWC and instead vesting the powers of chairman CWC with the president itself. It is to hereby state that contrary to the claims made in the new constitution book, the draft copy of the constitution was never approved by the 4-member constitution drafting committee, nor any state executive body meeting of People's Assembly was held to approve and ratify the same. The new constitution book cannot be deemed to be in operation as the same is illegal. After closely studying the affairs of the party leadership and members, strong opinion that the position of chairman WC is the imminent necessity and the wisdom of then party leaders to establish such a position within the party was well thought for. Further, the position of chairman CWC as the custodian, interpreter, and protector of the party and its constitution is paramount, and the same should coexist with the position of party president. Unless any amendments are done after following the mandated process, the undersigned is of strong opinion the PPA Constitution 3rd Amendment shall continue to be the guiding light for the party. Now, this complaint was given by the General Secretary, People's Party of Arunachal. Then, Your Lordship may see page 350 also.
The General Secretary means that after.
My lord, the first election, Your Lordship will find the President and Secretary General was appointed.
Okay.
Now, General Secretary, he was not convinced the way they have conducted all this.
He is also part of this team of the President and the Secretary.
No, earlier, they were the part of the entire PPA, including the chairman.
Yes.
Now, this election was just for 2 persons.
Okay. Now, so this General Secretary is part of this 2-person President and the Secretary.
President, General Secretary, he was also Secretary. No, he was not with them.
Not with them. This is on what basis he is writing this General Secretary?
As General Secretary, because the earlier committee is still continuing, because of the injunction order by the court, they are ousted. Otherwise, although term was expired,
no.
But then they were continuing. And
No, no,
suddenly,
whether he is a general secretary of the earlier,
earlier.
probably not.
Now also.
The
Earlier he was general secretary. Well, earlier, obviously, otherwise how we can write general secretary?
no. So the election of the
Earlier election.
That
means, my lord, it was up
election
to-
of the chairperson,
My lord,
the
up
next
to-
one against which the injunction was passed.
Yes.
Who is the secretary there?
After injunction was passed, before that.
The injunction passed against.
Easy party.
Probably is he the team
Just I'll check it.
of that?
And his name is?
Because
Inka naam kya?
now we have three party. One, the earlier one, next, the 14, 10, 22, and then 23 also.
Yes.
So three party. So
Three-
which party he is?
That is, let me check it up. Marley, na? Is not a party.
Don't know from which group he is general secretary. No.
So because now we have three.
Secretary.
One is the earlier one.
Earlier one.
Second is yours one. Third is
This
the present.
Marley company, we don't know from which group he is.
No, Marley Kamki, he was earlier, that expired on 2021.
No.
In that committee, he was
No,
there.
no, basically.
No, just a minute. Huh?
No, you continued after this 2014, 10, 2022. After the.
When the election was held, against which they have obtained injunction order?
Page 110, your lordship may kindly see. 110. Hmm, 11. 110, no. My lord, your lordship may see at page 111.
Yes.
Constitution Drafting Committee,
Marley
number
Kamki,
1, number 2,
member,
number 3.
General Secretary, PTM.
Marley Kamki, member General Secretary.
So that means earlier one.
Yes, and this is the annexure, my lord, they have annexed in their plaint. So therefore, these men, he was not satisfied the way they were conducting. And then he highlighted all this thing. And
So, and then whether is he also the team of the
This is
present,
1410.
the
14/10/2022.
no, thereafter?
Thereafter, yes, he's
Yours,
he's in the team. No?
He is not
He's
there.
No, he's not there.
So now, because after him, there is two election by the Respondent party and the
Two election. One
yes,
is
and then he's
22
still
and-
writing as a general secretary.
Yes. General Secretary earlier because it was the annexed by my learned friend. He was the member of the drafting committee.
Just a minute there.
And being not satisfied, even Rigam Santan also objected to it. Tai Tadap also objected. So these are the things
No, Marley
never.
Kamki. No, here also 2023. Can you see 346?
346.
He is still general secretary. Somewhere here.
346. Yes, Marley Kanki,
General secretary of
General Secretary.
this was 23.
This is the letter dated 24/9/2023 to the chairman for conducting election in terms of the party
So-
constitution.
So these are old team,
Old team.
the earlier team.
Yes,
So that is why they are writing to chairman.
right, to the chairman they are writing.
Please.
So these are the very vital things, my lord, we projected by filing this application, and the London civil judge never dealt with all this thing. You know, now which one? We have to go?
9.
कौन सा? Page 3 कितना बोला था? ये ना? Now, Melodial Lordship, kindly go through this page 345 to the Honorable Chairman.
Just a minute. Sir. Yes.
With due respect to the members, People's Assembly, Your Honorable Authority to take prompt action to conduct immediate election for state executive members to run the party smoothly. Otherwise, our party may defunct for another 2 consecutive terms in which the party might be freed by the Election Commission of India. We are shocking by the letter of Election Commission of India state that the PPA is not submitted the new elected executive members and party term has already expired in December 2021, and also question about party's present state executive. As the party is required to conduct the election in proper way in accordance with the guidelines of the Election Commission of India. Therefore, we pray Your Honor Authority to appoint 1 returning officer to conduct the party election as soon as possible as per the provision of party constitution. Now, these are the members who has given total, my lord, 23 members.
Okay, these, the applicants are the earlier executive
Earlier
members.
Earlier members, my lord.
So this is prior to the second election. The election.
Yes, yes.
Okay. Well, by the way, when the second election was held? After 1410.
Second election.
After one was held on 1410.
One is 14/10/2022, and our election was on WS. So the WS. हाँ, कहाँ लिखा है? This is 12/11/2023. That your lordship will find paragraph 10 of the plaint. Page कितना है इसका? $58.
1211.
1211. Page 88, paragraph 10 of the plaint. कितना पेज लिखा है? 350. मुझे दिखाया था कौन सा पेज? $345. So now which way to show? है ना? Then your lordship may see at page 350.
Page
348 and 350.
348.
348 procedure, yes, I have read it. Your lordship may turn to page 350. 350. 350.
Type copy 350A.
350 25/10/2024. 23. The type copy your lordship will find 350A.
Yes.
To the chairman and the president is by the treasurer. A new PPA constitution under the title of Fourth Constitutional Amendment is currently under circulation. In one of the party meetings held in the last part of 2023, I had proposed for constitutional amendment for removing the post of chairman CWC. But after that, I had no knowledge about any matters pertaining to amendments carried out in the PPA constitution, as no official formalities regarding the same was ever initiated by the party. Any amendment in the party constitution should go through proper channel and process. No proposal for constitutional amendment and publication of new constitution book was approved, either in the state executive meeting of People's Assembly, highest organ of PPA. The newly circulated PPA Constitution 41 amendment is an illegal publication and it cannot be treated as a valid party document. The present PRA party constitution is the genuine and authentic one. He is the treasurer of this 14/10/2022.
What he is referring about this present PRA?
PRA party. This is a PPA typing mistake. It should have been PPA party.
So
now he is the treasurer of this 14/10/2022 election. Even he was not satisfied. And my lord, I am now.
He is also earlier.
Earlier and present. Present means 14/10/2022 election. He is the treasurer. And
14/10/2022.
14/10.
Okay, he's part of their party.
Yes, part of the.
Okay,
And
but
these gentlemen, again, my lord, now I will take your lordships to a. His signature has been forged by this committee 14/10/2022. That I have made the amendment in page 186. Your lordship may see that paragraph 15. 186. Paragraph 15.
One 186,
paragraph 15.
paragraph 15.
That after receipt of the letter dated 18/9/2023 from the Election Commission of India, all members of the PPA party had also written a letter dated 24/9/2023 to applicant number 1 requesting the applicant number 1 chairperson CWC to conduct immediate election for state.
Just a minute, reading paragraph 15.
15, my lord.
Okay.
That after receipt of the letter dated 18/9/2023 from the Election Commission of India, all members of the PPA had also written a letter dated 24/9/2023 to applicant number 1, requesting the applicant number 1 to conduct immediate election for state executive members in accordance with the guidelines of the Election Commission of India. A copy of the letter dated 24/9/2023 is enclosed. This letter, your lordship will find at page 293-294. Yeah, yes, ma'am. Yeah. 293, your lordship will find page 293. He has written a letter to the chairman. Drafting committee, 4 persons has written that letter.
293.
293. Letter dated 24/10/2023, addressing the chairman CWC.
Yes.
With reference to cited above subject, we the undersigned would like to clarify the people reply made by the President PPA in the following few lines for your kind consideration. That, sir, it is a misleading information that Article 13 has amended and the post of CWC chairman has removed, which stated in his letter is purely a malafide intention to defame the great reputation of PPA, which founded by our great former leaders of the party. The letter replied by the president is deviated from the facts of the matter and tried to escape from realities. The fact is that on 24 September 2022 was an executive meeting to take a resolution to propose for amendment of the Article 13 by convening a People's Assembly to seek consensus to adopt the amendment by the People's Assembly. Unfortunately, the Article 29 amendment procedure has precisely written that the party constitution shall be amended only by the People's Assembly. The notice or proposal for amending the constitution shall be given 1 month before the said assembly, and invoking said Article 29 never been conducted till today. It is yet to convene the People's Assembly for party organization, election, and in due course of time, the Article 13 or any other article, clause, subclause of the party's constitution. Then your lordship may come to page 293, 294. Whereas the question of amendment to Article 13 or removal of CWC chairman does not arise, hence your kind authority is prayed not to confuse or feel ambiguity about the party's constitution. The party's constitution is vividly expressed the power and functions of the members of the People's Assembly and others therein. Therefore, your august office is prayed to convene the People's Assembly as soon as possible by virtue of expiry of the PPA tenure of 22nd December 2021. These are by the 4 members. One is Rigam Santana, Vice President, Taitada, President, Marli Kamki, General Secretary, then Tawa Tagar, Treasurer.
They are the members of the earlier executive body.
Then your lordship may come to page 187.
They are not of the 1410.
No.
Okay.
16, page para 16.
Yes.
Page 187, that the applicant number 1 under compelling circumstances issued a letter to the respondent number 1 dated 25/10/2023 to conduct fresh elections in accordance to law, failing which the applicant number 1 shall conduct the election for smooth functioning of the party activities. This letter your lordship will find at page 351. Three five one A is the typed copy.
Yes.
To the President, People's Party of Arunachal, with reference to your letter dated so and so, I am here to inform you that the letter which replied by you is irrelevant in nature, and there is no any substantial document, evidence, videographic that your authority has convened a People's Assembly to amend or the removal of CWC chairman as per the provision of Article 29. It does not fulfill the essential requirement of any alteration, amendment, amendation to the constitution of PPA. I have gone through all the records which is available in your party office, ECI website as informed by you. It is pertinent to mention here that letter dated 24th October 23, the clarification letter from your executive members, which precisely explain about the immaterial malafide intention to hijack the proper formalities procedure of PPA's organization election, as well as the alleged 4th amendment of PPA constitution, is not good tradition for the party's reputation. Hence, I'm inclined to honor the members of People's Assembly sentiment, and I shall have duly bound to uphold the party's status, reputation, and promise to abide by the Constitution of the People's Party of Arunachal Pradesh. Then the is 17, paragraph 17, is it? Same, no?
So this is the chairman writing to the president
Yes, yes.
after the election.
After the election, we requested them, you do it, but maintaining the mandate of the Constitution. Because mandate of the Constitution was never. My lord, your lordship may see once again 352. Which one? Yeah, no? ये पढ़ा है 352 typed copy 352A. Therefore, you are requested to convene a People's Assembly immediately to notify within 5 days of time whereby members of this People's Assembly could liberty to choose to elect their party's leaders. After expiry of stipulated time, I am being the chairman of Central Working Committee of PPA shall compel to convene the People's Assembly within short period of time and let them decide the party's future leaders for smooth functioning of party activities. Clarification letter to the Executive Committee, my notes, and this is by Comment Ringo. उसके बाद statement whatever to say. 295, 296 required for sure. Please. Lordship may come to page 189.
Yes.
Para 20.
So we are skipping 17, 18, 19.
189. Skipping these other paragraphs, not necessary.
Okay.
Your lordship may take up to 20, para 20. The respondent number 1 along with respondent number 2 have for long caused grave problems for the PPA party and have continued on their post, arbitrarily causing chaos among the members of PPA. So much so that all members are against the respondents and none of the members are ready to accept either the 4th Amendment of the Constitution of the Presidency of the respondent number 1 as the elections have not taken place according to procedure for any law prescribed under the Constitution of PPA. Hence, in order to restore the party discipline in the capacity of the chairman of CWC, the applicant number 1 notified the circular dated 4/11/2023, calling for People's Assembly to be held on 12/11/2023, which was informed to the Deputy Commissioner as well as published in the local newspaper. These, your lordship will find at page 297, 298. Yeah, no? You can skip this. Lord, these are the papers related to our election. So this is not much helpful in this case. We can skip this part.
Yes.
These are not the matter of adjudication. Then your lordship may kindly come to page 190.
190.
Paragraph 21.
Yes.
That the People's Assembly meeting was conducted on 12/11/2023 at Arunachal Pastora Hall, Itanagar. The entire problems and scenario of the PPA party was discussed in detail and resolved. The People's Assembly on 12/11/2023 declared the 4th Amendment of the Constitution of PPA as a nullity, as it was done without following due procedure of law. That on the same day, the People's Assembly also elected new executive members for the session 2023-2026 under the returning officer Sri Lukhe Boje and assistant returning officer Sri Takam Taluk, which was attended by 301 members, inclusive of executive members, the detail with regard to which also accordingly submitted to the Election Commission. Now, these are not necessary to take your lordships. Now, there are 22. Your lordship may come to page 199, 191, paragraph 23.
Okay.
That is representation. That is representation with regard to the decision made on 12/1/2023 and nullity of the Fourth Amendment of the Constitution of PPA is already pending before the Undersecretary Election Commission of India, New Delhi, as all relevant documents with the recent developments and update was sent by the applicant number 1 on 16/11/2023. Then your lordship may come to page 192, paragraph 25. जरूरी है इसका Melody, your lordship may skip this. Lordship may come to page 193, page 20, para 26. That due to the illegalities found within the political party during the 2022 elections, the formerly appointed Vice President of PPA party, the Rigam Santana, has also filed an FIR before the officer in charge Itanagar Police Station against all illegalities found within the PPA party. This FIR, your lordship will find at page 330. The FIR filed by Mr. Rigam Santana, Vice President, former Vice President. It is to bring to your immediate notice that one Sri Logam Tagia and Sri Biri Jai has illegally claimed as Assistant Returning Officer of the party organization election dated for 12/14 October 2022 without knowledge of state executive members and central working committee, whereas Sri Taba Tagar and Kaling Jerang signatures were forged and shown as 356 delegates of PPA were also fabricated without details proof of delegated members in which the documents have submitted before the Election Commission of India dated so and so. It is pertinent to mention here that there was no such party organization election of the party dated 12/14 October 2022 and calling of People's Assembly, which was published in local newspaper in advertisement form thereof. However, myself as Vice President of the state and others were appointed in the month of September 2022, namely Sri Tai Tadap as Yat President, Sri Shorang Koikan as so and so. Unfortunately, without conducting party organization election by calling People's Assembly to participate in the party election process and appointed us as state executive members after lapse of 9 months of time. Later on in the month of October 2022, the state president Sri Kafa Bangia, in order to avoid any formalities, objection from party members as well as Election Commission of India, has appointed Sri Taba Tagar as returning officer and myself, Rigang Thanga Santana, as assistant returning officer for namesake and to fill up the prescribed format of Election Commission of India. Subsequently, they have submitted before the Election Commission of India and same has rejected by the ECI and directed to submit with proper prescribed format of party organization election dated 18 September 2023. Thereafter, aforementioned 4 persons, namely so and so, had submitted fake documents once again before the ECI dated 27/9/2023. Hence, every single document is fabricated and concocted against the constitutional provisions of People Party and guidelines of the party organization. Therefore, your kind. Then please
So he himself says that for namesake.
Yes, yes, namesake. In fact, there
To
was no
fill up.
election. ये था ना एक कोर्ट्स का एक document था ना.
What happened to this FIR?
FIR, my lord, is pending. I don't know whether investigation, how far it is gone.
So
Then I will take
not
your
registered also. Any case
Registration.
registered?
registration of what? No, we are not aware of it.
Okay.
Now, my lord, I will take your lordships to another paper, which will show. Oh, जो fraud था ना एक ठो. 86. My lord, I'll draw your lordship's attention at page 273.
273.
273. This is the election result on 14th October 2022. Name of candidate Sri Kafa Bengia, President, elected unopposed. Then Rigam Santana, Vice President, elected unopposed, and he has filed the FIR. Just now I have read. Then Kaling Jerang, Secretary General, elected unopposed.
No, he's part of that team.
Yes, but then
But he filed this FIR.
yes, being not satisfied of their activities, my lord, he had to file the FIR against them.
Just a minute. This FIR was dated.
FIR was dated 30. After the institution of the suit. Page 330, my lord.
9/1. 28. This is dated. I think after a year.
Yes.
But then at the time of offering this portfolio, he accepted.
Why I'm taking your lordship to all these,
Yeah.
my lord, the learned trial judge, when all the materials were placed before him, was it not his duty to take the evidence? Now, the legal formalities. Say in the case, there will be, my lord, if there is a delay, there will be irreparable loss. But then so much of things we have placed for you, the incumbent upon the learned judge to take the matter into logical conclusion. Now, without taking any evidence, you have accepted that whatever the plaintiff has said, that is the case. And when the defendant has said, that should be brushed aside. That cannot be the type of adjudication. And then, my lord, in these page 273, a very interesting thing your lordship will find. In the bottom, my lord, the Sri Taba Tagar said to be returning officer. Now, your lordship, for a while, kindly see the signature. It is the fourth signature of Taba Tagar. And the signature, the real signature, your lordship will find at page 287.
Whether Tabatagar has also lodged any FIR?
Tabatagar has complained, but he did not file FIR. Your lordship may see page 287. Signature, world of difference. Now, these are the very important and serious issues which was projected before the court. And the court was reluctant to accept anything.
By this result, Tabatagar, who is said to be returning officer, is also been elected unopposed as treasurer.
Yes.
And then he is also returning officer.
Right. Now, all these, my lord, irregularities are there, and it was highlighted, and there was no adjudication to that effect. Even my lord Lagum Tagya is a non-member. See, Birija, he is a non-member.
Where was the signature? Just a minute. Where was the signature of Tabata, original?
Yes,
signature
at
of
page,
Tabatagar?
your lordship kindly see at page 287.
287.
On the right-hand side, in the extreme right-hand side below.
Okay. So this is treasurer.
This is real signature. Now, in the face of all this thing,
this result was declared on 14 October. So this is, but then this Tabatagar himself has written this.
Yes.
To the chairman on 25/10, after that only.
Right.
So he had accepted, I think, then.
Now, these are the things, my lord, the matter of evidence. Why I am showing it. These are the things which should have been adjudicated by taking evidence. But the learned judge did not do anything. Well, these are very serious matters. Therefore, the element of fraud writ large in the case. And when such type of illegalities have been focused before the court, and without going into all these things, you are passing some order, there is no reason why you are passing the injunction order. At least why we file an application to vacate that, we have projected the entire matter. What is happening there? What is the illegality? And what is our finding? Finding is that even if there is a violation in the constitutional mandate, even then, my lord, they are entitled to get the injunction.
Is there any stay in the proceeding of the?
My lord, what happened? 2023 election, this is the correct election, the valid election. Now, by virtue of stay order, what happened was when the order which given to us against us, we have been injuncted even to enter into the office. We cannot use the official seal. We cannot use the emblem, nothing.
Whether this court has stayed the proceeding in the trial court?
Yes, yes. No. Trial court has trial court passed ex parte order. We filed this application.
Thereafter, in the title suit, whether it is proceeding is?
No, proceeding is now it's stayed. I think it's not going on.
Not going on. But whether this court has stayed?
No. It is adjourned and fixed it when? Oh, after adjudication of this very innocuous order. Very innocuous order passed. That means after the disposal of this case, they will start.
After?
Disposal of this case.
In the order sheet itself, it is reflected.
Is it?
Not
Yes,
reflected.
what we said, all the parties, we agreed that because the matter is already pending before this honorable court for decision of.
Could have proceeded.
No.
Could have.
Proceeding has not been stayed, ma'am. We agreed to. But
So that is why I'm saying, if there is no stay, could have proceeded.
no, this proceeding is going on in the other one. But in other case, there was some, they had paid for interim order and almost same. I will come to that later when I'm sure, ma'am.
Okay.
This matter was kept.
Okay.
Anyway, since they are not going to it, but then question now, which your lordship is required to adjudicate, is when we have projected the entire thing. My lord, my submission would be first that at the time of ex parte order, when the court passed, there was nothing before the court. So court possibly thought is a matter of ex parte injunction can be given, all right, you have given by after the scrutiny of the statement made in the plaint. because the court thought whatever they have stated in the plaint may be correct and passed an ex parte order. But then when we came before the court by filing an application under order 39(4) to vacate that order because there are serious illegalities committed by the plaintiff. Because plaintiff asking for some relief and they could not articulate all these things before by filing an plaint, as well as they could not convince the court by giving an evidence because before that they have taken party order. Now, when we have clarified everything, that so much of illegalities one by one, that was never dealt, and I will take your lordship a decision from the Bombay High Court and the Apex Court. The lordship has said that when certain things has been projected by the defendant, the court is duty bound to deal with that, and then you pass an effective order. Now, here in this case, your lordship has seen so much of illegalities have been projected. There is no finding. There is no reflection in the order sheet that court has gone into all that. So therefore, at this stage, when the application under order 39(4) was placed on record, the court should have adjudicated taking into the points taken by the plaintiff as well as by the defendant. Okay. Now, therefore, my lord, your lordship has seen there is this fraud signature and all these things. Even then, my lord, the learned judge did not do anything. And
But this like Taba Tiger's full signature and all, unless the person concerned.
no, there's a question of evidence.
Agitate.
My lord, what I'm saying, those are the allegations, but then it is required to be proved by adducing evidence. So therefore,
that is true.
Therefore, learned judge ought to have vacated that order and could have passed an order. You give evidence on that, and within 6 months, the matter by this time it could have been made over. So whatever we say in the plain or written statement, these are not all gospel truth. These are required to be proved by way of giving evidence.
Right. Okay.
Now, therefore, now your lordship can see at page 57, this application, how it was dealt. I'll not read, I'll just go to apparative part. 57.
Page 57.
Page 57, yes. I'll take your lordship from page 61.
This is the order passed in the vacation application.
Yes, yes.
Yes.
Order passed by the learned civil judge. Page 61, paragraph 19.
Yes.
Order 39, Rule 4 CPC reads as follows. Order for injunction may be discharged, varied, set aside. Any order for an injunction may be discharged or varied or set aside by the court on application made thereto by any party satisfied with such order, provided that if an application for temporary injunction or in any affidavit supporting such application, a party has knowingly made a false or misleading statement in relation to a material particular, and the injunction was granted without giving notice to the opposite party, the court shall vacate the injunction unless, for reasons to be recorded, it considered that it is not necessary to do in the interest of justice. Now, why we are saying, my lord, misrepresentation of fact? Because Article 29 was never complied, and had they complied, they would have stated in their plaint. Now, there is no averment that we have complied. Article 29, there was a People's Assembly by giving notice for 1 month. After the 1 month, People's Assembly took place. Now, once you do not state that facts, the court was not knowing whether Article 29 is complied or not. It is your utmost endeavor ought to have been that you should make that statement so that the court can know that the whatever statement you have made, it is a correct statement. So therefore, they have misled the court. It is a representation of the misrepresentation of the fact, and therefore, if it is so, then the order is liable to be vacated. Now, ultimately, my lord, what she has said, your lordship may come to page 62, paragraph 21. In the present case, the defendant has sought vacation of the ex parte order dated so and so. The contention on behalf of the petitioner defendant is that the plaintiffs had made false statement and misled this court that there has been fourth amendment to the constitution of PPA and the post of chairman CWC was removed. Plaintiffs furnished copy of the resolution along with signature of the state executives. The letter dated 24/10/2023, Annexure 3 of the application also shows that the state executives did not deny that there was a resolution for amendment of the constitution. Therefore, in my view, the plaintiffs may not have followed, this is very important, may not have followed the procedure provided under the constitution for amendment of the constitution. However, the contention of the petitioner cannot constitute evidence that the plaintiff had made false statement. This court is of the opinion there is no knowingly false or misleading statement made by the plaintiff in the plaint or in the interim application for temporary injunction, and at best, an incorrect, inadvertent statement has been made by the deponent of the plaint. Now, your lordship, kindly see why the court should be party to the misrepresentation of fact. Because why we are saying, once you do not say about the Article 29, anything you do not say, that itself becomes a misrepresentation of fact. You commit a fraud when you do not say all these things, because the order obtained by committing fraud, and the Apex Court has said any order obtained from the court by playing fraud is a, my lord, the order is a nullity, and that can be vacated by any court. Even, my lord, the court of Supreme Court, even the higher court's order, the High Court's order may be vacated by the Munship also, if it is a nullity. Now, this formula squarely applies here also. Then I will take your lordships to the appellate judgment. That is also more dangerous, my lord. Your lordship may come to page 44. I'll just take to the operative part. Your lordship may see page 54, para 18.
This is para 18 of what?
Para 18, page 54. This is appellate judgment.
Appellate judgment.
Yes.
Okay.
From the para 18. From the aforesaid highlighted portion of the impugned order, it is seen that the learned court below has duly considered all contentions, both the parties of the application and order 13 and 1 in the Miss case, and has referred to relevant articles of the Constitution of PPA, and thereafter come to the decision that although Fourth Amendment of Constitution of PPA made by Respondent number 1 and 2 and other members of PPA executive body has not complied with the provision of Article 29 of the Constitution of PPA, which requires people assembly to be held and 1 month prior notice, but same cannot nullify the election held on 14/10/2022. My lord, your lordship kindly see, my lord, with all respect, I would say,
yes,
totally oblivious of the legal position. My lord, once 29 is not followed, that itself, my lord, goes to the root of the thing. And now what is, he has accepted it is not followed.
Yes.
Has not complied with the provision of Article 12 of the Constitution of PPA, which requires People's Assembly to be held and 1 month prior notice, but same cannot nullify the election held on 14/10/2022, which was conducted by duly appointing a returning officer and by complying with due procedure for conducting an election as required under Article 38 of the PPA. My lord, I'll further read another thing, very interesting thing your lordship will find. It is seen that the learned court below has further reason, on the other hand, that the election held on 12/11/23, by which appellant was re-elected to chairman, CWC shall be considered illegal for violating the provision of Article 38 of the PPA Constitution, as appellant had no power to appoint any returning officer to conduct any election, even if assuming appellant was the chairman of CWC of PPA. In my opinion, the aforesaid reasoning and decision made by the learned court below does not show anywhere that trial court used its power in arbitrary, capricious, perverse manner. Now, your lordship kindly see, he is, my lord, appreciating the weakness of the defendant case. Now, where is the finding? Finding is given wrongly, totally illegally. He has to say whether the claim made by the plaintiff that the election which held on 14/10/2022, he wants that election to be valid. His prayer is that number one, that declaration he requests. Once you want that declaration, it is your burden to show that that election was valid. Well, there is no paper in this, in the plaint, he did not say anything. Even my lord, learned judge is not also asking that you show your that the election mandate is in terms of the legal provision. And the court also did not go to that extent. Rather, they are saying, my lord, so far defendant is concerned, in Article 38 it says the returning officer will have to be appointed by the president. And here it is by the People's Assembly who has appointed the returning officer. Therefore, they committed illegality in appointing the returning officer.
What the 38 says?
What 38, your lordship can listen. Small book. Article 38.
Party election.
Yes.
The president in consultation with the state executive shall appoint. Okay.
Yes.
So it has to be the president who.
My lord. My lord, that's a different aspect. Now,
yes.
You are to see the plaintiff's case. Now here, I just from the beginning I say that both the court proceeded the case with a reverse angle, because plaintiff has to stand on their own legs. You cannot take the weakness of the defendant.
Right.
You are to establish your case first. My case will come later. You show that you are entitled to get a decree that election held on 14/10/2022 is a valid. Then the court will pass, yes, your election is valid, the finding will have to be there. There is no finding whether there was valid election on 14/10/2022. Without doing that, they're coming to a finding saying that the election through returning officer, which returning officer was appointed by the People's Assembly, that is wrong. And therefore, the election is invalid and that election has been stayed. So whether it can get through the scrutiny of law, that is the whole question. And that is the question which has to be answered by all the courts.
The one question is that the amendment.
Yes.
Doing away with the chairman.
My lord.
And the next is the election of the president.
No. My lord, first thing, my lord, if your lordship look at the plaint, my lord, again, I'll take your lordship, the para at page 70. They will have to first primarily establish their case, page 90. Page 90 for declaring the plaintiff's right
Just a
over the
minute.
title of People's Party of
Just a
Arunachal.
minute, page 19.
90.
Sorry, 90.
Now, this is their first claim. They will have to establish this. Right over the title means the election which held on 14/10/2022.
Yes. In June election result right now.
Declaring the plaintiff's right over the title of People's Party of Arunachal, although it is not in a direct way, but they want to say the declaration of plaintiff's right that election which held on 14/10/2022 is a valid election. Now, if this is so, then where is the finding of the learned judge? Where is their case, plaintiff's case, that they have, my lord, complied all the mandate of law? They are saying, my lord, on that date, the Constitution was amended. Now, how the Constitution could be amended? This is by People's Assembly. Now, whether the People's Assembly ever took place, if it is there, then whether 30 days notice was given, where from we get it? Absolute nil, nothing is there. Now, unless you get this decree by you have some sort of materials on record, and the finding the learned judge will come to it, they will have to satisfy that those election which took place on 14/10/2022 is a valid election. Now, where is that, my lord? Without doing that, they have come to our case. The defendants, my lord, appointed a returning officer in terms of Article 38, that is to be appointed by the president. Now, here your lordship kindly see whether this president who is against this party, I mean against us, whether he will appoint the returning officer in our case is almost impossible. But I am not going to that because first you have to get through in regard to prayer number 1. And then you make some other scrutiny. I am not required to prove my case here.
So, supposing the stay is vacated, then who stands in the power?
My lord, stay is required to be vacated because what has happened here? My lord,
Assuming the stay is vacated.
My lord, declaration, this declaration, where is that declaration? Declaration has not been made. They are saying, just like they are saying that they have.
Because if the stay is vacated, then
we are in power, my lord. In fact, the chairman is
that-
still there. Because of the ex parte order of the court, we have been made ousted from there.
No, supposing if stay is vacated, whose power stays?
Power,
Because now there will be two power.
my
in the
lord,
party.
since our election has been stayed.
Because they are also elected now,
Yes.
claiming unless they are also stayed, unless their election is stayed.
No, that power, it is our power, my lord. Because we are legally formulated election was held. And since it's a legal election and the earlier one, what they are saying, 14/10/2022, there is no paper that they have been elected that way.
Now, that having not yet been declared as illegal.
Well, otherwise, if your lordship, because I am the chair, only because of the stay order, I am not, this injunction order, I am not there. Otherwise, I am the chairman.
Because there is a challenge. You have also challenged their election.
Yes.
Your election has been challenged. Supposing stay vacated. Now, if the stay is vacated, then we have a three power. One, the earlier one, next, their election, and then yours.
No, these body will function.
This body.
This body will function.
But yours
is our chairman.
But they are also claiming that they have
they will have to establish their right.
And unless their election is stayed.
That will be just interim measure. Otherwise, the moment it will go to the trial court, Let them prove their case. But once they can prove their case, they will sit. They will be in the driving seat. But they will have to get through in the exam. Because they will have to prove their case. Whether on that day there was an amendment.
Their election is prior to yours at the moment.
It may be. But then your lordship kindly see, on even, my lord, take a case that 14/10/2022, there was an election. Say, let us say it's a valid election. Now the amendment was done after that, 4/11/2022. Now his election as a president will have to be approved by the chairman. Where is that approval? That is also not there.
But can we also, because your election is also certain notice, certain notification, or it has to be initiated by the president only. So yours also having not done that.
No, we have done.
There was no president.
We have sent the notice, we have circulated the notice.
No, there was no president at the moment, at that time.
No, chairman will do. In absence of president, the chairman has the power. Chairman is the apex body, my lord. He is only alone. He has to take.
The law says that it has to be the president who has to.
Here the problem is the president is doing anti-party activities.
Under that has not yet been declared that president is doing anti-party activities.
No, there is a complaint by the chairman.
So then
chairman
there has to be some declaration that because president is doing some anti-parties, and then because of that, the president's power has been now seized or something against the president. Some order has to be there by the organization.
What happened here, my lord? The president himself has initiated the election without maintaining the provision of the constitution. They will have to comply the provisions of the constitution. So therefore, if anybody, say president or secretary general, if they start taking the election procedure and all that in their hand without the approval of the chairman, then there will be anarchy. And it had happened.
Now here is the case where the president and secretary, earlier president and secretary, both of them are there.
President and secretary general.
Yes, president and secretary, along with others also. So now here is only a chairman. You are only chairman.
No, chairman and 22 members.
So unless it is declared that the president and secretary having done the anti-party activities, their power, now you have to constitute some interim.
No, that my lord,
power. Who shall organize? Who shall organize or conduct election?
The chairman is holding the post. Now
where do we find that in absence of or in the event of the president and secretary doing anti-party activities that the chairman will be responsible? Do we have in the law? So,
I know, my lord, what I'm saying, so if this order is vacated, the chairman will come in the power because he was in power, but because of the injunction order, he is out now. Now, if your lordship says that the matter can be sorted out by the trial court within 3 months, let them go and prove if the election is valid. They can prove it. The election which held on 14/10/2022, the Article 29 was complied. If they can prove that, they will come in the power again. It's a matter of 3 or 4 months. If we do all the endeavor without taking any adjournment, that can be sorted out. Because we have been in these cases more than 6 months possibly. By that time, it could have been made over. So this is the only way what I feel. It may send back there, let them prove their case. Whatever happens, it will happen. But law must prevail ultimately. But here your lordship kindly see the order of the trial court as well as the appellate court. The main core question that they ask for declaration of plaintiff's right has not been gone into, no adjudication at all. Whereas the appellate court further came saying that defendant has not done that way in proper way, so their election is still. This is not the way, my lord. Civil case cannot be decided that way.
This morning you referred that right over the title It should not be titled. What should it should?
It should be, my lord, it cannot be, election result cannot be said to be a title.
What it
The, for declaration that plaintiff's right in regard to the election held on 14/10/2022 shall not be constitute to be valid. So title is in regard to some property and all that. The election result is not a property. So therefore, this is the first prayer which has not been, my lord, established yet. See the order of both the court. And then now, my lord, I will take to your lordships the.
So this first prayer should have been instead of title with regards to the election, your election.
Yes, yes. Their election. They want
their
to
or
mean,
yours. Sorry, their election.
Their
It
election.
should be their election.
They want to mean that only because election which was taken place on that day, that is a valid election. Now, my lord, I would like to take your lordship to certain decision. It will not take much time, my lord. I'll finish it only. The important para I will highlight. Really, है ना? Okay. First this much. First, I will take your lordship to 2018 SCC online, Bombay 3043. I am giving a copy.
Okay.
Bombay High Court decision I have found is the best decision, my lord.
This is Bombay High Court.
Bombay High Court.
Okay. Para 22.
Para, your lordship, kindly see from para 22 to 25.
2018.
2018 SCC online.
Any
Bombay.
latest after this?
Yes, yes, I am happy. I'll take your lordship one by one. Paragraph 22.
22.
It is right that a plaintiff who approaches the court, particularly in order to seek any equitable interim or ad interim reliefs, which are essentially discretionary, must not suppress any material fact or particulars, but must make true and correct statements in the plaint or in the application seeking such interim relief. This is a case where a clear misstatement of fact, and that too quite a material fact, has been made by respondent plaintiff in the plaint, on the basis of which respondent plaintiff have applied for interim relief. Unfortunately, though this issue was squarely raised by appellant's defendants, my lord, as we have taken to the application of Order 39 Rule 4, we have stated everything, all averments, but it was never adjudicated. That their lordship is saying. Unfortunately, though this issue was squarely raised by appellant's defendants in their written statement, reply to application for interim relief, as also written submission filed before the learned trial judge, the same has not even been adverted to by the learned trial court. Your lordship has seen, she has not adverted to all the objections we have raised. Has not been adverted to by the learned trial judge in the impugn order. It is not the case of respondent that such a issue was not argued before the learned trial judge so as to excuse non-consideration of such relevant and vital issue. This is therefore a case of total non-consideration of a very relevant and vital issue, which imports the exercise of discretion in a matter of this nature. In Wonder Limited, this court, my lord, the learned judge also relied. In this case, what happened? The Wonder Limited case, Appeals Court is saying, appellate court judgment, the trial court judgment, unless there is arbitrariness is there, the appellate court will not interfere. Very correct. Now here the same thing, we have shown the arbitrariness because the election which held on 14/10/2022, it was not in compliance of Article 29. Therefore, this arbitrariness was never adjudicated by the trial court. Rather, they have said there may be a violation, but it will not affect the election result. It's very difficult to, reconcile how she has passed that order. In Wonder Limited, the Honorable Supreme Court has held that in appeals against essentially discretionary orders, appellate court will not interfere with the exercise of discretion of the court of the first instance and substitute its own discretion except where the discretion has been shown to have been exercised arbitrarily. This is exactly our case. Then your lordship may skip that. The last few lines I will read, my lord. 25. Last 3 lines, para 24. In this case, one of the settled principles in matters of grant of refusal of interlocutory injunction is whether the plaintiff or the applicant who seeks such interlocutory injunction has approached the court by stating all the material facts and relevant facts in its knowledge. Where the plaintiff or applicant misstates the facts or suppress facts which are vital and relevant to the cause, then in the absence of some very good explanation, such plaintiff or applicant is ordinarily not entitled to discretionary and equitable relief. Then para 25. In this case, as noted earlier, the learned trial judge has not even considered the issue of misstatement and suppression on the part of respondent plaintiff. Exactly our case. This constitutes ignorance of the settled principle of law regulating grant or refusal interlocutory injunction. It is not as if this issue was not squarely raised and argued before the learned trial judge. It is not as if such issue was insignificant or irrelevant in the matter of deciding an application seeking equitable and discretionary relief of interlocutory injunction. The total non-consideration of such issue makes a dent to the decision-making process, even applying the restrictive parameters prescribed in Wonder Limited. Then para 27. In any case, even assuming as submitted by Mr. Kane that the learned trial judge in the present case is deemed to have considered the issue of misstatement, suppression, or even acquiescence, and further rejected such issue, then it is at once apparent that such rejection is bereft of any reason whatsoever. It is tried that reasons are very the soul of decision making. In the absence of any reason, it is just not possible to even appreciate as to whether the learned trial judge was alive to these vital and relevant issues, the basis for the so-called deemed rejection of the same. Now, my lord, here also the trial judge never gave any, lord, reasons for such rejection. Then para 31, my lord. The Submiller India Limited.
We're skipping 28 and 28. Okay.
Para 31 now. This the lordship has decided one case of Apex Court. I'll also be relying on that. In Submiller India Limited, the learned single judge of this court has in fact followed the law laid down by the Honorable Supreme Court, that is 1994 1 SCC page 1, but has distinguished the said judgment on facts by pointing out that the facts and documents which were alleged to be suppressed by plaintiff were not material or relevant. Now, in this case, my lord, your lordship has to see the whatever material we are saying, it will have to be material document, relevant document. So here also, my lord, in terms of Article 29, if you say that amendment was taken, that amendment will have to be by People's Assembly, not by executive members. Secondly, the notice of 30 days is a must. So these are the very material aspect you have suppressed. You did not say in the plaint that we have complied with. You never complied with. So therefore, this decision also very vital. Distinguish the said judgment on facts, pointing out that the facts and documents which were alleged to be suppressed by plaintiff were not material or relevant to the issue involved in the suit, and therefore the Changfalaria principle was inapplicable. The learned single judge has held that had the plaintiff stated facts or produced the documents which are alleged to be suppressed, it would not have had any effect on the merits of the case. The learned single judge has also relied upon such distinction carved out by the Honorable Supreme Court itself. In 2004-7 SCC 166, where again it has been held that issue of suppression sufficient to deny relief can only arise where the suppression is of relevant and material fact. Then your lordship may see at para 45.
We are skipping 41.
Oh, 41 is also there. 41, the trial court, even on conservative basis, will require at least 2 to 3 months to decide the issue of interim relief afresh. Instead, the interest of justice would be better. My lord, what I am submitting exactly here it is given. Instead, the interest of justice would be better served if after setting aside the impugn order, directions are issued to the trial court to dispose of the main suit itself as expeditiously as possible, any case within a period of 6 months from the date of production of authenticated copy of the order. Now, in page 45, the lordship has said instead of 6 months, it may be 4 months. 445, your lordship kindly see at this stage, Mr. Kane, learned counsel for the respondent, submit that direction been issued for disposal of the suit in 4 months instead of 6 months. The decision in the case of Bajaj Auto Limited, direct disposal of the suit within 4 months. Now the next decision, Lord, 2005 SCC online, Bombay 5. I think it is given there, no? Except the end. It's not, sir, I go there. My lord, I will rely on para 8, 9. Your lordship may take paragraph 8. The learned counsel,
Just a minute.
yes,
Para 8.
para 8.
Yes.
The learned counsel for the respondent submitted that this petition deserves to be dismissed with exemplary cost because the petitioner has deliberately suppressed the material facts from the court and has not approached the court with clean hands. They submitted the petitioner has deliberately suppressed and concealed following vital facts and introduced false facts to mislead the court. The respondent number 2 offered the petitioner employment on, your lordship may skip that para 9 then.
In the present case, is it really the concealment of the fact?
Yes, definitely, because my lord, your lordship kindly visualize one thing. If there was an election on that date and there was an amendment on that date, then the amendment can be done by the People's Assembly. Now, whether the People's Assembly was there on that date, there is no aberrament in the plaint. And if the amendment can be done by the People's Assembly, none other than that body. And then if in that case 30 days notice will have to be given. Once you withheld those facts from
So the fact
plaint,
which is required for their election is needed to be stated in the petition. It's
yes,
required to be.
my lord, when you want a ex parte injunction,
Right.
then you must state the entire fact, the whole truth. Because on the basis of this material only, on the basis of plaint only, the learned judge is going to pass an order. So therefore, the learned judge will visualize that whatever is stated in the plaint, these are all truth. There is, because you will have to make all endeavor that, because injunction when we are going to take from a court.
But in the appellate court or in the vacation petition, you have stated all these things.
But they did not deal.
Okay.
It was, I can understand at the first instance when the ex parte order was given.
It was
The
concealed.
court may not
That
have.
amounts to concealment on the part of the petitioner.
On the part of the petitioner, there is a concealment of
Okay.
fact. Now the
And then
concealment,
thereafter, after you have apprised about the existence of these,
there is no of the thing.
so
They could have given the finding on the basis of the allegation made,
okay.
but court has also become party to that.
Hmm.
Therefore, My lord, court did not deal because this decision of Bombay, their lordship has said that when we are taking some point either in the written statement or in the interim application, my lord, when we ever that court will have to deal. But in this case, your lordship has seen so much of allegation made, they did not deal anything. There's some cryptic order without any reason they have passed. And when you pass ex parte injunction, you must give a reason. No reason given. Now, para 9. In concise Oxford Dictionary, fraud has been defined as criminal deception, use of false representation to gain unjust advantage, dishonest article of trick. According to Halsbury laws of England, a representation is deemed to have been false and therefore a misrepresentation if it was at the material date false in substance and in fact. Then para 11, fraud according to Black Law Dictionary, 6th edition is an intentional perversion of truth for the purpose of inducing another in reliance upon it to part with some valuable thing belonging to him or to surrender a legal right. A false representation of a matter of fact, whether by words or by conduct, by false or misleading allegation, or by concealment of that which should have been disclosed, which deceives and is intended to deceive another, so that he shall act upon it to his legal injury. Then your lordship may skip all this. Then para 19. This is very important. The lordship, on relying on the case 1994 1 SCC, they have observed the courts of law are meant for imparting justice between the parties. One who comes to the court must come with clean hands. We are constrained to say that more often than not, process of the court is being abused. Property grabbers, tax evaders, bank loan dodgers, and other unscrupulous persons from all walks of life find the court process a convenient lever to retain the illegal gains indefinitely. We have no hesitation to say that a person whose case is based on falsehood has no right to approach the court. He can be summarily thrown out at any stage of litigation. A fraud is an act of deliberate deception with the design of securing something by taking advantage of another. It is a deception in order to gain another's loss. It is a cheating intended to get an advantage. A litigant who approaches the court is bound to produce all the documents executed by him which are relevant to the litigation. If he withholds a vital document in order to gain advantage on the other side, then he would be guilty of playing fraud on the court as well as on the opposite party. Then in the 99 SCC online, Bombay.
So we skip the rest of the paragraph.
The rest of the paragraphs may not be gone into.
Not be required.
This decision your lordship may see at para 8.
Yes.
It is now well settled that a matter where a party seeks an equitable relief, the party has to approach the court with clean hands and should not suppress any material fact or document, otherwise he or she cannot seek indulgence of the court for any equitable relief. The case in and the finding arrived at by the trial court, duly supported by the record, disclosed that the fact regarding execution of the lease deed in the year 1968 by the owners of the property in favor of the petitioner number 1 and his father, as well as the fact regarding the admission on the part of the respondent regarding possession of the suit property being claimed through the petitioners in the earlier suit being special case number so-and-so between the owners of the property and the respondent were clearly suppressed from the trial court. Not only the said facts were suppressed, but the documents pertaining to those facts were also not disclosed to the court. It was only after filing of the written statement by the petitioner that the said facts and documents came to light. In this regard, learned advocate for the petitioners is well justified in placing reliance upon the judgment the matter of so and so, so and so. The suppression of material fact by itself is a sufficient ground to decline the discretionary relief of injunction. A party seeking discretionary relief has to approach the court with clean hands and is required to disclose all material facts which may, one way or the other, affect the decision. A person deliberately considering material facts from court is not entitled to any discretionary relief. The court can refuse to hear such person on merits. A person seeking relief of injunction is required to make honest disclosure of all relevant statements of facts, otherwise it would amount to an abuse of the court. The reference may be made to decision so and so, so and so. Your lordship may skip the other part. And 2004-7 SCC, page 166, paragraph 13. My lord, I'll be relying on paragraph 13. Yes. As a general rule, suppression of material fact by a litigant disqualifies such litigant from obtaining any relief. This rule has been evolved out of the need of the courts to deter a litigant from abusing the process of court by deceiving it. But the suppressed fact must be a material one in the sense that had it not been suppressed, it would have had an effect on the merits of the case. It must be a matter which was material for the consideration of the court, whatever view the court may have taken. Thus, when the liability, my lord, this is the factual thing. The more question is the relevant facts and the material fact should not be suppressed from the court. ये क्या है? Now, this is the case I am highlighting, my lord. In the name of giving the interim relief, you cannot give the whole relief. I will be relying on 2003-6 SCC, page 65, paragraph 16 and 17. Nextly, we notice that the High Court has granted a relief by way of an interim order, which we think it could not have done at the interim stage for more than one reason. The writ petition in question was filed challenging an order made with the government in revision. The subject matter of the said petition pertains to the liability of the respondent to pay the tax. The said writ petition, the respondent has sought an additional prayer by UFA direction to the respondent to grant an NOC to relaunch its airline operation. We do not want to say at this stage that such joinder of two separate causes of action could be maintained in a writ petition like the one that is filed before the High Court by the respondent. It should be noticed that the authorities empowered to permit relaunching of the airline's operation were not before the court, which we are told is the Department of Civil Aviation. Be that as it may, since the relief as termed in the writ petition being a final relief, we think the same could not have been granted by the High Court at any interlocutory stage. Now, exactly in this case also same thing happened. In the name of interim relief, the whole relief has been given. Then para 17, seen from any angle, we think the High Court has erred in granting the impugned relief to the respondent, which in our opinion is in the nature of a final relief which on facts and circumstances of this case, without deciding the issues involved in the writ petition, could not have been granted. Therefore, we allow the appeal and set aside the impugned order. The NOC is, which is said to have been issued provisional stance report. This thing. Now, my lord, on different aspect, I will take your lordships that the plaintiff will my lord, will have to stand on his own legs. They cannot rely on the weakness of the defendant. That is 1988 4 SCC, page 539. Your lordship may see para 10.
9.
It must be remembered. Para 10.
It should be 9, I think.
Oh, oh yes, 9. Your lordship is correct. It must be remembered that exhibit P1 is only an offer made by the appellant plaintiff, which was preceded by certain correspondence emanating from the respondent. It can reasonably be presumed that subsequent to exhibit P1, there must have been some response from the respondent to the offer of the appellant. All those documents were not placed before the court to appreciate correctly and completely the transaction between the parties. Further, as rightly pointed out by the trial court and the first appellate court, that Gudhyal Singh PW1 was examined only to prove exhibit 1, and he was not in a position to explain the intricacies thereon. In particular, the relevant condition 2, which relates to supply and return of material. The language used, namely wet to wet, was not at all explained by PW1. The whole evidence of PW1 has also not been placed before us. We are of the view that the lower appellate court was quite justified in observing that the appellant board, for reason best known to it, had not placed all material, and no effort has been made to explain what, according to business terminology, was meant by supply of the steel wet to wet. We cannot take exception to the conclusion taken as above by the lower appellate court. The plaintiff appellant must succeed or fail on his own course or own case and cannot take advantage of weakness in the defendant respondent case. Yidya, 2011. Sunil Kumar. There are 10. एक ही है ना? Then one Calcutta decision, my lord, 2011, 0 Supreme Calcutta 1415, relying on paragraph 10. Lordship may look at para 10. Admittedly, plaintiff is not entitled to get a decree on the basis of weakness of the defendant's case, and the plaintiff's case must stand on its own legs. It is also a settled principle of law that defendant is authorized to put up different defenses and every contrary defenses through his written statement. Much argument was made in relating to clause so and so, that your lordship may skip. 2014 ना क्या नाम है यूनियन ऑफ इंडिया ओके 2014 2 SCC page 269 paragraph 12 to 16.
Yes.
It is strike law that in a suit for declaration of title, the burden always lies on the plaintiff. But in this case also, it was burden on them. To make out and establish a clear case for granting such a declaration, and the weakness, if any, of the case set up by the defendant should not be a ground to grant relief to the plaintiff. The High Court, we notice, has taken the view that once the evidence is let in by both the parties, the question of burden of proof pales into insignificance, and the evidence let in by both parties is required to be appreciated by the court in order to record its finding in respect of each of the issues that may ultimately determine the fate of the suit. The High Court has also proceeded on the basis that initiate burden would always be upon the plaintiff to establish its case. But if the evidence let in by the defendants in support of their case privileges the case set up by the plaintiff, such evidence cannot be ignored and kept out of consideration. At the outset, let us examine the legal position with regard to whom the burden of proof lies in a suit for declaration of title and possession. In a suit for declaration, the plaintiff are to succeed. They must do so on the strength of their own title. The onus to prove title to the property in question was on the plaintiff respondent in a suit for ejectment. Now, this part, Your Lordship may skip. Then para 20. The legal position, therefore, is clear. The plaintiff in a suit for declaration of title and possession could succeed only on the strength of its own title, and that could be done only by adducing sufficient evidence to discharge the onus on it, irrespective of the question whether the defendants have proved their case or not. We are of the view that even if the title set up by the defendants is found against in the absence of establishment of the plaintiff's own title, the plaintiffs must be non-suited. We notice that the trial court as well as the High Court, rather than examining that question in depth as to whether the plaintiffs have succeeded in establishing their title on the scheduled suit land, went on to examine in depth the weakness of the defendant's title, exactly like our case. The defendants relied on the entries. Now, the other part, Your Lordship may skip. Now, 77-4 SCC, page 467. 567.
I think we are running out of time.
Well, just, I think 10 minutes, I'll wind up.
Okay.
Para 5, 6, and 7.
5, 6, and 7.
We have not the slightest hesitation in condemning the petitioner for the gross abuse of the process of the court repeatedly and unrepentantly resorted to. From the statement of the facts found in the judgment of the High Court, it is perfectly plain that the suit now pending before the First Munship's Court, Bangalore, is a flagrant misuse of the mercies of the law in receiving claims. The learned Munship must remember that if on a meaningful, not formal, reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, he should exercise power under Order 7, Rule 11 CPC, taking care to see that the grounds mentioned therein is fulfilled. And if clever drafting has created the illusion of a cause of action, nip it in the bud at the first hearing by examining the parties searchingly under Order 10 CPC. An activist job is the answer to irresponsible lawsuits. The trial courts would insist imperatively on examining the party at the first hearing so that bogus litigation can be shot down at the early stage. The penal code is also resourceful enough to meet such men and must be triggered against them. In this case, the learned judge, to his cost, realized what George Bernard Shaw remarked on the assassination of Mahatma Gandhi is dangerous to be too good. The trial court in this case will remind itself Section 35A of the CPC and take deterrent action if it is satisfied that the litigation was inspired by vexatious motives and altogether groundless. In any view, that suit has no survival value and should be disposed of forthwith. We regret the infliction of the ordeal upon the learned judge of the High Court by a callous party. We more than regret the circumstance that the party concerned has been able to prevail upon one lawyer or the other to represent
to the court a case which was disingenuous or worse. It may be valuable contribution to the cause of justice if counsel screen wholly fraudulent and frivolous litigation, refusing to be beguiled to the society.
This citation is with regard to?
My lord, in regard to the fact that if supposing a bogus litigation is placed, it is totally up to the court to nip it at the bud. Now, here is a case, if your lordship see the plain, is not a case at all to give an extraordinary injunction order in a which can be given in exceptional case only. Then 83.
I think that is enough. You have some more.
Some more, my lord. I'll just
okay. The relevant one.
I'll give it to your lordship.
Relevant one.
Let us see.
Let us see. The relevant one. Only the relevant.
Only relevant. No? Another. Ek minute. My lord, I'll give one decision. Morgan Stanley nikalo. And very important decision. It is Morgan Stanley. My lord, when under extraordinary circumstances, the ex parte injunction can be given.
Okay.
And other decisions, my lord, I have marked the para. Your lordship can look into it. I'll not read out. It will take much time.
Okay.
I'm also a bit tired. Shouting,
yes, I know.
Shouting very badly. Yeah?
This is
my lord, I'll read para 36, 37. Court masters will also angry because I am delaying.
36, 37.
Ek did. My lord, your lordship kindly see para 36.
Okay.
As a principle.
Yes.
As a principle, ex parte injunction could be granted only under exceptional circumstances. The factors which would weigh with the court in the grant of ex parte injunctions are, now they have narrated A, B, C, D like this. I'll halt on E. Your lordship kindly read E.
B.
The court A, B, C, D, E. Next page. The court would expect a party applying for ex parte injunction to show utmost good faith in making the application. That means whatever plaint you made, it must be with utmost good faith. Whatever the contention you made, in order to get the correct order, you must help the court also to give a correct finding. Because ex parte order you want to get at the threshold without giving any evidence. Therefore, my lord, we will facilitate, my lord, with the lawyer when we make a prayer for granting ex parte injunction. If we are really careful, the statement make with utmost good faith, whatever is required for the court also to pass an order. Now, if we make all the statements correctly, honestly, in that case, my lord, the order passed by the court will not be faulty because they will be guided by our utmost good faith character. Now, if it is so, the ex parte injunction can be given. These are the exceptional circumstances. Then para 37. No injunction could be granted under order 39 rule 1 and 2 of the court unless the plaintiff established that they had a prima facie case. Now, in this case, my lord, prima facie case has not been gone into by the, my lord, lawyer, by the court. So, this is all about. Now, other judgment you have, de dena. My lord, other there are many decisions I have paragraph mark kar diya. Or if your lordship, my lord, one decision, it is for, my lord, I enjoy it reading all the time. I want to read the last decision.
Okay.
2012 5 SCC hai na?
2012.
2012 5 SCC page 370. यहाँ पे है.
Which one?
I think with that
Stay.
punch. Or I'll read it and I'll give it my copy. This decision, my lord, talked about section 30 CPC.
2012.
2012, my lord, 5 SCC. This is Maria Margarida. It's a very good decision for the civil judges, my lord. I'll read paragraph 31, 32.
It's not there. Yes. It's online. Online. This is online. Well, SCC, okay. 2012. 2 SCC.
Maria Margarida, party's name.
Yes.
Your Lordship may see para 31, 32. The heading is Truth as Guiding Star in the Judicial Process.
31, 32. Yes.
In this unfortunate litigation, the court's serious endeavor has to be to find out where, in fact, the truth lies. The truth should be the guiding star in the entire judicial process. Truth alone has to be the foundation of justice. The entire judicial system has been created only to discern and find out the real truth. Judges at all levels have to seriously engage themselves in the journey of discovering the truth. That is their mandate, obligation, and bounden duty. Justice system will acquire credibility only, and people will be convinced that justice is based on the foundation of the truth. In Mahanlal Shamiji versus so-and-so, this court observed that in such a situation, question that arises for consideration is whether the presiding officer of a court should simply sit as a mere umpire at a contest between the two parties and declare at the end of the combat who has won and who has lost, or is there not any legal duty of his own, independent of the parties, to take an active role in the proceedings in finding the truth and administering justice. It is well accepted and settled principle that a court must discharge its statutory functions, whether discretionary or obligatory, according to law in dispensing justice, because it is the duty of a court not only to do justice, but also to ensure that justice is being done. Then para 42. In civil cases, Your Lordship got it.
Yes.
In civil cases, adherence to section 30 CPC would also help in ascertaining the truth. It seems that this provision, which ought to be frequently used, is rarely pressed in service by our judicial officers and judges. Section 30 CPC, they have defined that. Then, my lord, your lordship may also see 51, 52, 53. In the administration of justice, judges and lawyers play equal roles. Like judges, lawyers also must ensure that truth triumphs in the administration of justice. Truth is the foundation of justice. It must be the endeavor of all the judicial officers and judges to ascertain truth in every matter, and no stone should be left unturned in achieving this object. Courts must give greater emphasis on the veracity of pleadings and documents in order to ascertain the truth. Then they said about the pleadings. Pleadings are the foundation of litigation. In pleadings, only the necessary and relevant material must be included, and unnecessary and irrelevant material must be excluded. Pleadings are given utmost importance in similar system of adjudication. Now, ultimately, as the lordship has seen, the pleading is the backbone of the civil case. Now, if there is utmost good faith in making the averments in the plain, it helps the honorable judges to come to a correct finding. My lord, I wanted to say many more things, but then the time constraint,
yes,
I'm ending up.
Okay.
So I think my learned friend will reply next day. I may be excused.
It seems,
No problem, no problem.
otherwise all are tired, man. Your lordship might also not
No.
feel like listening to it anymore.
So, when do we fix for you?
Manoj, I'm always here, man. Anytime I'm.
Okay, so.
My learned friend will represent next week.
So tomorrow it may not be possible because the list has already been prepared.
Yes.
Hmm.
Day after tomorrow, we'll walk you. I'll not take much time, man.
Okay,
I'll maximum half an hour.
okay.
Otherwise, one of the missiles that were fired, one of this exactly those missiles I'm going to fire upon them. Same thing. So,
Okay, Mr. Yes, the planning senior counsel, as he said by T.Y. Bhutia, planning counsel for the petition staff. The hearing in respect of the. Then that is fine. The hearing remain inconclusive. As prayed for by the land council for the parties, list this matter again on.
one of the just convenience again, one of the feelings maybe having difficulties understand. Because this week would be proper, otherwise your lordship will also forget things what was.
Yes, when do you want?
This already prepared. Yeah, for tomorrow, for me, anybody can be here, or they have to, otherwise they can listen to online also.
17.
Day after tomorrow, Wednesday or Thursday?
Thursday.
Okay.
Okay.
Thursday is, what date is it? Okay.
I'm so grateful for such a patient sharing given by your lordships.
We've seen the strength, power, and perseverance of the land council. Who is of course elder, very senior.
Stamina.
You know, stamina. Appreciate, huh? Okay.